May I remove my mask?
Yes, please.
Thank you, Your Honors. Your Honors, and may it please the court, I'm C. Thomas Brown. I represent Elliot Dixon. He's an individual who was hired by FEI Enterprises to do work on a project at the Pentagon. Since this was a case at the Pentagon, Mr. Dixon didn't have any opportunity to file a mechanics lien, so he's protected by the Miller Act. Your Honor, we come here on three issues from the trial court below. This went out on a summary judgment, Your Honor. Issue number one is, did Mr. Dixon supply labor as that term is meant under the Miller Act? Number two, the court found, and Your Honor, I submit the court was just incorrect on this, but found that the contract, main contract between the government and the contractor had been terminated on concluded, I think is what the court said, on January 31, before the last day on which Mr. Dixon did work. We'll talk about that. And the third issue is, Your Honor, even if we get to those two issues, was Mr. Dixon led to believe that he had more time than necessary to file his claim? And there's a letter that was written, Your Honor, it's in the joint appendix at 230, which clearly invites Mr. Dixon to go and redo his claim and submit his claim under time circumstances where he was led to believe that the insurance companies would pay his claim if he did that.
Mr. Brown, I've looked at every legal dictionary I can find, including Black's. Is there any definition of the word labor that does not include mental exertion?
Well, Your Honor, I don't know if there is any definition. I know that the definitions, at least for this court, and for many of the courts out there, we have the constructor's case and we have the Olson case, which was cited in the constructor's case, and they talk about what labor means under the Act. And, Your Honor, I can get to that very quickly. And, Your Honor, on-site supervision is included in the term labor. There's no question about that. Moreover, in this case, Mr. Dixon did do a lot of physical labor on this job. He showed up every day. We have two affidavits from him. We have deposition testimony. He showed up every day. He hauled stuff to a dumpster. He cleaned up at the end of the site. He put up fences. He ground down concrete. He watered concrete. He assisted subcontractors. He was an hands-on guy.
What was the last act of labor he performed?
February 8th, Your Honor, 2019.
And what did he do then that qualifies as labor under the Miller Act?
He was asked by the government to go to the site to conduct an inventory of what was on site and what was already installed. In order to do that, he had to take a bunch of Schedule 40 pipe, I think he talks about. He had to actually move it from one spot to another. He had to count it. He had to measure what pipes were in the ground. And so, Your Honor, he did physical labor on that day that he worked at the specific request of the government.
So now, what case indicates that taking an inventory is labor under the Miller Act?
Well, Your Honor, I don't think there's any case that addresses taking of an inventory. But remember, Your Honor, this is an on-site physical inventory. This isn't a thing where he sat back in an office and looked at a bunch of invoices and added things up. He went to the project site. He went through security. He got to the project site, and he started basically moving Schedule 40 pipe, moving wires, counting things up, identifying what was in the ground and what was left on the project. It was one of the things the government had asked him to do, which I think also bodes into the second argument. Was this contract included at the time, which it wasn't? Your Honor, I think the cases that give you guidance on this issue are...
Well, does the time of the termination of the contract have any impact here? If, for instance, we were to conclude that the February the 8th inventory was not labor, what difference would the termination date of the contract make?
Well, Your Honor, the argument of the trial court was, or at least the finding of the trial court was, if you supply labor after a contract's over, it's not labor under the Act. Here, this contract, that is, this was a separable contract. We had certain parts of the contract that were terminated and were concluded, certain parts that were not concluded. And the government said, we're going to revisit this. We will on February 1, 2019, revisit and let you know what we're going to do on the second part of the contract. So the fact that this contract
Do
is
we have a copy of the contract?
Your Honor, we have copies of the letters which cite what they're doing and has sites.
We don't have a copy of the contract.
The prime contract, Your Honor? No, we have a copy of the subcontract, but not the prime contract.
Okay. And I guess the question I've got, the contract with the government, which maybe you can't answer this because it's not in the record, and maybe this is a question that we just can't answer on appeal, but was the inventory required under the contract?
Yes, Your Honor, the inventory was required under.
How do I know that? I mean, I'm not doubting you as a person, right? But you know, we rely on the record and information that was presented to the trial court, and I'm having a little trouble figuring out how I could determine if this issue was relevant. Accepting Judge Agee's point, whether the complete post-completion inventory was required by the contract.
Your Honor, if we look at the two letters that were sent by the government in this case, the first one terminating the contract, and then a second letter a couple of days later, which unterminates part of the contract. And in there, they talk about actually the inventory. They talk about, Your Honor, FEI remains responsible in Apex 1 and 2. FEI is the general contractor. For the work, until the work is finished, the work site is cleaned up, all the requirements are submitted. FEI must proceed on Apex 1 and 2 by no later than December 31, 2018. And Your Honor, I think in one of these letters, they talk about the actual inventory as part of that work. Your Honor,
I know that they request an inventory. I understand that, but what I didn't see, and I'm happy for you to point it out, is where it says that was required by the contract, right? Because the Miller Act applies to labor provided under the contract.
Well, Your Honor, we certainly know that the government said it was required under the contract, and that's in the email that was sent to Mr. Dixon. The email that was sent to Mr. Dixon, which is in the record, let me get it, Your Honor, under which he did the work. See if I can find it real quick, Your Honor.
I can read the email, but the best place you've got for me to find that the contract required the inventory that was done is the email that you represent suggests that that's a contractual requirement. In other words, that it comes out of the contract itself, though we don't have it.
And it is, Your Honor, because it says that, you know, we want you to go do this inventory. It was required to be done before December 31st. We need it to be done at this point in time. So it clearly referred back to an existing obligation under the contract for the general contract to do this work that was now being picked up by the subcontractor, Mr. Dixon. So, Your Honor, perhaps during the 5 minute, when I'm sitting down, I'll see if I can find that for Your Honor and readdress that when I get back up.
Assume that we don't find that this labor included mental exertion, but we do know he did some physical work. How would the district court parse out how much he's entitled to as by way of compensation?
Well, Your Honor, that's just an issue of proof, and that's not something that should be decided on summary judgment. But, Your Honor, I would suggest that once you trigger the Miller Act, and the language, Your Honor, from all of these cases is very similar, and it says, however, the term doesn't include a professional, or excuse me, the term does include an architect or another professional. My client was an engineer who actually superintends the work as it is done on the job site. The constructor's case, Your Honor, said if the superintendent did some physical labor at the job or might have been called upon to do that physical labor. He clearly did physical labor, and he clearly was called upon to do physical labor. So, Your Honor, once you trigger labor under the Act, the issue is one of proof. We were never able to put the proof on before the court, because we went out on summary judgment. But clearly there are daily memos that went to the file. And there's a huge record in this case underneath that we weren't able to put on. But in that daily record, Your Honor, it shows what was done on every day of the job. And Mr. Dixon can identify what he did on those days. And that ranges, Your Honor, from cutting off handrails, painting handrails, watering cement, grinding down cement, things of that nature. Now, Your Honor, even if you find that the matter is not timely, I would suggest that under the Humble Oil case, and Humble Oil is very similar to this case, Your Honor, very, very similar. Timing of it is this. Mr. Dixon files his claim with the bond company.
So are you going to write to an estoppel argument?
It's a waiver and estoppel argument. There's no question, Your Honor, that Humble Oil is a blueprint of this case. And, Your Honor, if this letter doesn't tell Mr. Dixon.
Before you go there, let me ask you, if the court were to determine, for instance, that the February 8th, I believe, inventory was not labor within the Miller Act, would you agree that the complaint was not timely filed unless there was the application of estoppel?
Well, Your Honor, I mean, the question is, you're asking me to assume that he didn't do any labor on site that
Correct.
day.
That's just an assumption.
So I would suggest, Your Honor, he did do labor on the site that day. But if you find that he didn't do labor on site that day, then it's an estoppel issue. We know that he did work in January after this letter. It's in his affidavit. It's also in his testimony and his deposition, all of which are part of the record. And he would have filed within a year, but he thought the insurance company, because they told him, we will pay your claim, we'll adjust your claim once you refile it.
In your statement, I mean, I get you just slipped up and said it, but doesn't that sort of reveal the trouble you've got with the estoppel argument? I understand if the letter said, we will pay if you comply with these procedural requirements, you'd have, I think, quite a good estoppel argument. The problem is you just caught yourself in saying it doesn't say that.
Well,
right?
actually, it kind of does. So let me just read from the letter itself.
Let me start by saying it doesn't say that.
It doesn't say that, but this is what it says, Your Honor. Joint Appendix 231. All right. It talks about notwithstanding the insufficiency of your proof of loss, and they talk about all the different things. It then says, please consider the above referenced standards.
Counsel, which letter are you reading from now?
This is the Watt-Teeter letter of January 14, 2020.
All right.
This letter is over a year after the claim was initially filed with the bonding company, and just before the bonding company says the end of January is when the statute runs. This is the middle of January, sent by mail. He gets it maybe 5 days before this time period runs. He doesn't know anything about it. He doesn't have a lawyer at the time, unlike in Humble Oil where the guy did have a lawyer. Here it says, resubmit your proof of claim in accordance with the guidelines, including removal of all hours, et cetera, et cetera. And last sentence, once the surety has received your revised proof of claim, it will conduct another review to determine any amounts recoverable under the payment bond. So he gets this and he says, look, they're going to tell me what's recoverable under the payment bond.
And do you agree that if a claim is made outside of the statute of limitations, that it is not recoverable upon?
Well, the claim was made within the statute. There's no question about that. Question is whether the lawsuit's filed.
Some of us might have a question about it. I know you think it's no question about it, but let's assume for a minute that it, just in a hypothetical case, accept a hypothetical for a minute, that it was not filed within a statute of limitations. Do you agree that that claim would then not be recoverable upon?
But if the proof is not filed, that's right, Your Honor. But in this case, there's no question. The proof, and I can find it in the record for you, hadn't been an issue in the case. Trial court didn't make it an issue. But the proof, the claim was initially filed in January of 2018, 2019. The proof, the actual signed sworn proof, was provided in July of 2019. This letter comes in January 2020 after that and says, look, we don't like your proof. It acknowledges there's a timely proof. And it then says, your proof's insufficient because it doesn't do this, this, and this. Redo your proof, resubmit your proof, and we will conduct another review to determine the amounts recoverable under the bond.
It says any amount recoverable.
Any amounts recoverable under the bond. And so, Your Honor, he clearly is believing.
What about the concluding sentence? The surety reserves all rights.
Well, Your Honor, I think if you go back and read the trial court's the decision on this, what the trial court says, and I'm not sure where it comes from. He goes a little beyond that, but Your Honor,
right? But
when he says the surety reserves all rights.
Wait a minute. So, but what do you say this last sentence of the January 14, 2020 letter means.
Well, I'm telling you, Your Honor, I think this is an issue for the trier of fact after Mr. Dixon takes a stand. What do you think it means? The surety reserves rights. Doesn't say reserves all rights, just reserves,
No,
it can be reserves all rights.
Reserves
Right.
all rights.
Doesn't tell them what rights are being reserved. It doesn't say we reserve our right to deny your claim if you file your revised claim after a year from when you last did work. Doesn't really give him any information at all. Remember, we're dealing with a guy who's working on a project site, an individual. All he's looking for is his day in court to be paid on a project where he did the work and he supplied the labor for the Pentagon. And Your Honor, I see my time is up. So,
but you've got time on rebuttal.
Okay, I do, Your Honor. Thank you.
Thank you very much. Mr. Winkham, did I pronounce that correctly?
Mr. Winecam.
Winecam, all right,
Pretty
sir.
close though. It caused some trouble.
Go right ahead.
Good afternoon, Your Honors, and may it please the court. My name is Dominic Winecam, appearing on behalf of Appellee Fidelity and Deposit Company of Maryland, the payment bond surety in this action. We're not here today to determine whether appellant is entitled to recover under a subcontract with the prime contractor, a subcontract for the performance of project management services on a nearly $12 million project at the Pentagon. Appellee has never maintained that the appellant should be left uncompensated to the extent that he was left unpaid by the prime contractor. However, appellant's remedy lies against the prime contractor and not appellee, the Miller Act payment bond surety. The protections of the Miller Act are not intended to be all-encompassing, and not all work done in connection with the construction project is compensable under the Miller Act.
Well, the plaintiff did do some manual labor here from time to time, and there's a string of Supreme Court and other cases that seem to indicate that some of that manual work mixed in with more cerebral work does qualify as labor.
Yes, Your Honor, and you know, appellant has relied heavily upon these cases. I submit that there has been a preceding line of cases, starting primarily with Constructors v. Gulf Insurance, that began to parse that distinction more carefully. And the more recent case from California.
Can I sort of turn you to a case I don't think we've focused on, which is Bankers Surety of Cleveland versus Maxwell. So it's a Fourth Circuit case from 1915 that interprets the Hurd Act, which is the predecessor to the Miller Act. And it seems to adopt, relying on a Supreme Court case called Cullins from the 1880s, a position that's contrary to yours. And this is not a gotcha moment. If you don't know about it, you can just say you don't know about it and that's fine. But I'm having a little trouble squaring that Fourth Circuit case law, which is controlling on us or arguably controlling on us, with the argument that you're making that a on-site supervisor who does some manual labor, or in fact, I think they suggested might be called upon to do labor, qualify.
Yes, Your Honor. And so let me first start by saying that I am not intimately familiar with Maxwell. I've read it, and I've read the cases that appellant primarily relies upon, which are in that vein. And we admit that, and we've attempted to use our briefing to do a more exacting analysis of the appellant's affidavits and comparing them with the Gulf case and with the prime mechanical case.
I understand that, but what I'm saying is that under Maxwell, which is like the binding law here, defining what labor means in the Fourth Circuit, it's inconsistent with the argument you're making, at least as to what labor means, right? Because it says that supervision on site where no labor is done, but where you might have to do labor, qualifies as labor, quote unquote, under the term.
So, Your Honor, we would factually distinguish those cases, and in addition to previously mentioned, would reference the scope of work for the appellant's contract and his position as the project manager. So he was a supervisor of supervisors, and his contract, he was not required to be on site. And so, to the extent that he was on site performing this task, that would be, he had the discretion to do that, and we submit that the district court aptly recognized that it creates a dangerous precedent to permit individuals to create their own Miller Act protections. And so the district court didn't look at it as closely as looking through his contractual obligations, but his contractual obligations were not to perform the types of services that he detailed in his affidavit. And just to circle back to the first point, when you do look at some of the types of services that are detailed in some of the newer lines of cases, it's a matter of terminology sometimes, but you could just as easily say that the site coordination services that were rejected on a motion to dismiss in Gulf, is that inconsistent with Max Sutwell in the previous cases, or can they be interpreted to say that there is a more nuanced definition of what types of services are intended to be protected by the Miller Act as it develops over time? And so we submit that this is a natural development of the labor standard.
Well, as a follow-up to Judge Richardson's question, has this circuit ever excluded professionals from recovering under the Miller Act?
No, Your Honor, and we're not seeking categorical rejection of claimants based on their job title alone. We're attempting to do so in this case based upon the scope of contractual services and comparing and doing a detailed look at the types of services that he claimed to have performed that were incidental to his primary job as a project manager on this.
Well, why don't you give us a synopsis of why the things he didn't do are not Miller Act labor?
Yes, Your Honor. So we've done that in the briefing by taking his affidavits and the affidavits of Keith Forney and Steve Townsend,
right,
and looking at
maybe you can give us a kind of condensed version of that. Absolutely,
Your Honor. So the types of labor that are contained in the affidavits and deposition testimony are, well, first of all, they're very general, and they include surveying, cleaning up the site, and moving materials around. And so, I think that it's very difficult to say what is and what is not labor, picking up a pen.
What about if we had a crew, we had a construction crew, and on the construction crew, one of the people assigned was the youngest guy on the team, and his job every day was to go around and clean up after everybody else. Would we call that guy having provided labor?
I don't know. You'd have to look at it in the specific case, but
I've just described a specific case. That's what I'm trying to get at, right? So if a guy, his sole job was to do the things you just described, right? He cleaned up after the other workers, right? So he took out their trash and he swept the floor and he, picked up nails that got bent and he cleaned up.
Yes, Your Honor. And that's where we look to the scope of contractual obligations. Now, if you look at the appellant's contract, it's for project management services in accordance with the requirements of the prime contract. Now, if you had an individual whose sole job was to provide site cleanup services, I think we'd have a different case because his payment would be tied towards the performance of the service. He would be at risk of not fulfilling his contractual duties for failing to perform those services. Whereas appellant here, there were times during the project where construction.
He falls, I just want to make sure I understand. Your argument here is we would have to look at that employee's employment contract with the subcontractor and determine whether that contract required him to do cleanup or not. And we're looking at not the contract between the government and the contractor, but the worker's contract and what it required him to do. And if it didn't specify, then he's just out of luck. It just said you show up and work as required.
Your Honor, I believe that depending on what the contract language said, if the contract was silent as to the performance of those duties, then you would look to what the contract did say and whether those tasks were fundamental to the type of labor being claimed or whether they were incidental, did them at its own volition, or that sort of issue. And you would look towards what was he being paid for? How is payment being processed? And how was he receiving direction? In this case, appellant, as the project manager, had substantial discretion and employees beneath him that were site superintendents, safety officers, in order to direct and perform that. And so by stepping in and doing some of that himself, to the extent that he did, is he permitted to draw himself into the class of protected labor? And that is if you accept that performing, and you can look at the volume of performing the activity. Someone who is on site every day and is called upon to do that every day as part of their job versus, their main job is running the project. And in the gaps, they step in and sweep up a room. And so hopefully I've answered your question, but those are our positions and interpretations regard to how they fit within the context of prior case law.
Can you answer or address Judge Agee's, I think, first point, which was whether the work done on February 8th, sort of assume for a minute that you lost everything before that, but we just were asking the question about February 8th. And your colleague suggests that it was labor, I take primarily because he said he had to move pipe, Schedule 40 pipe. I don't know what Schedule 40 is, but I assume it's just pipe of some sort. Why would that not qualify as labor under your view of the case?
Well, Your Honor, we rely on case law, and there's two reasons why the February 8th work is not Miller Act labor. And first of all, just to directly address the question, is why in and of itself it's not Miller Act labor, is that cases from other jurisdictions have told us that and that's, I'm referring here to the Northern District of Georgia Ricky Tittle case, where if I read you the facts from that case without identifying information, you'd struggle to tell the difference between the two. In that case,
but that's a district court case.
It is, Your Honor. But that is
what's your best Court of Appeals case from somewhere on this point?
Your Honor, I believe the East Coast electric or mechanical case was affirmed in a table decision and bears upon this point. It's the Mavis mechanical case was affirmed by the Fourth Circuit. It's unpublished, but it's after a subcontractor had one item of work left to complete, which was the installation of a valve, and left the project. Now, during the course of the next year, they came back two different times. The first time they attended a meeting, and the second time, the principal for the subcontractor made an attempt at installing this valve. And the court looked at both of those attempts and did not establish either one of them as qualifying as labor sufficient to establish a starting point for the Miller Act statute of limitations. And so, in addition to just looking at the labor itself, so you've got that case, and you've got the Ricky Tittle case, which is directly on point factually to this case, even though it is a district court case from another circuit. This is where the second argument relies on the status of the work at the time. Now, in this circuit, the standard, or the traditional standard for determining whether a specific act qualifies for Miller Act purposes for the statute of limitations, is whether it was part of the original contract work or whether it was warranty remediating defects. And so, this case presents a little. You have to go a little bit further in this case, because the appellant was not required. He was not responsible for the incorporation of any specific work into this project. And so, he doesn't have any. There's no construction defects for him to correct or work for him specifically to complete as the project manager.
WHS ever terminate the separable portions of the contract that it preserved action on?
No, Your Honor. So,
what's the consequence of that?
Yes, Your Honor. So the consequence is that the contract naturally concluded, and the substantive work was completed by January 31st, 2019. And so, why would an inventory be being conducted if there was still work going on? This is part of the closing out of the natural conclusion of the project, which that's not the end point for, or that's not necessarily relevant for Miller Act statute of limitations purposes or the traditional standard. as of December 28th, 2018, that last portion of the work, there was 0.1% of work that was left to be done. And Forney Enterprises completed that physical installation of work by January 31st, 2019, the extended deadline. And so there was no termination because that part of the work was done and Forney Enterprises was off the job.
Do you agree with your colleague that what I'll call the closing inventory was required under the contract? I mean, we don't have the contract, which is a little hard, but he represents that it was required by the contract. Do you agree with that the contract required the contract itself required a closing inventory?
I disagree. And
tell me why, and tell me what in the record,
yes,
since we don't have the contract itself, which is a little frustrating, but since we don't have the contract, why should I believe that it was not required by the contract itself?
Yes, Your Honor. So if you, and co-counsel may be preparing these emails, but if you look at those emails between Forney Enterprises, the appellant, and the government during that period from January into February 2019, the meaning of those emails becomes apparent. The government was requesting this inventory as in order to reconcile the materials and make final payment. It was for the benefit and for the government to issue payment to Forney Enterprises as they were leaving the job. And so it was not for the government's benefit. It was for the government was belaboring Forney Enterprises to conduct this inventory so that they could have everything just tied up at the end. And so, unfortunately, like I said, we don't have the prime contract before us, but there's the conducting of a materials inventory is not something that you're required to do when a contract naturally completes. It was for the purposes of the appellee stepped in and performed the terminated portion of the contract. So it was determining what was left for both the terminated and non-terminated portions just to get a status of the work. It would not have occurred but for the fact that the other portions have been terminated. If the non-terminated portions had just been completed January 31st, 2019, there would be no reason to inventory the materials. The work would have continued on the terminated portion if that portion had not been terminated. So it's a function of the termination and Forney Enterprises no longer being on the job.
Just to make sure I understand that, you wouldn't need a closing inventory because they would have moved that pipe or whatever it is to the next apex.
To the next apex. It would be the work would be continuing. That's correct, Your Honor. But because Forney Enterprises was terminated in December 21st, 2018, once the work on the non-terminated apex was done, it was time to take note of the status of the work, which was in a state of flux owing to the termination. So just to briefly touch upon the estoppel arguments, appellants rely almost.
Well, let me on the issue of the application of statute of limitations. If we were to assume that Mr. Dixon performed Miller Act labor on February the 8th, would his complaint have been timely?
Yes, Your Honor. The Miller Act statute of limitations is 1 year from the date of last performing labor. And I'll add one caveat, of course. So if you determine that this is qualifying Miller Act labor, which that determination should take into account the nature of the work and the nature of the work should take into context the nature of the contract as a whole, which is the status of the termination. So that's my caveat. But my answer is yes. If all of those conditions are met and this is qualifying Miller Act labor, then the suit was filed February 5th, 2020, which is within 1 year.
Okay. Well, if we assume on the other hand that February the 8th was not Miller Act labor, now tell us about the estoppel argument.
Yes, Your Honor. So the appellants rely on humble oil, which is, it establishes standards that are just not met in this case. The hallmarks of the humble oil estoppel are a promise to pay and protracted negotiations, a lack of a reservation of rights. And so we have several cases from courts within this circuit where we have much more similar facts, such as data staff and that East Coast machinery case again, where in data staff there were written letters where the surety actually incorrectly informed the claimant that that they were not a proper claimant on the bond, which the claimant then relied upon, and the surety informed the claimant that we're open to considering other information. Now, those types of statements were not interpreted to be promises to pay. And that's very, very similar to what we have here, where it's the surety is open to reconsidering its decision, its rejection of the claim upon receipt of that proof that would allow for payment. And just like in those cases here, we have not only the reservation of rights that's contained in the January 14th, 2020 letter, we also have in June of 2019, the initial request by the appellee for the proof of claim, which contained even a more detailed reservation of rights. There were no promises to pay. There were no, and their express reservation of rights, and there was nothing that the appellant should have reasonably relied upon.
All right. Anything else you want to tell us?
Thank you, Your Honors.
All right. Thank you very much. Mr. Brown?
Back with you, Your Honor. Okay, let me start, Justice Richardson, with your question, and was it required by the contract? If we go to 141 of the joint appendix, that is the second page of the first letter that was written by the government on December 20th, 2018. And they go through the requirements of the contract, and it then says FEI remains responsible for Apex 1 and 2 until the work is finished, the work site is cleaned up, and all required deliverables are submitted. FEI must proceed in good faith to complete Apex 1 and 2 by no later than December 31, 2018. That was later changed. FEI must provide an inventory of all materials on site and at any off-site location as soon as practicable, but no later than 31 December 2018. Now, that date was later extended by the government in the email, which is found at Joint Appendix 305. The email, it's in a bunch of different places in the record, but this is within the affidavit of Mr. Dixon, where the email says that its subject is final request for materials inventory, bond number, blah, 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 blah. And it says, Elliot, please submit the materials inventory no later than 5 p.m. Monday morning, 11 February 2019. So they pushed it back to February 11th, which is the day he got this. He goes out to the site, and it says the materials inventory was due on December 31, 2018. This is your final notice in this matter.
Right, but so just so that I understand, so I read the first letter as saying you got to do the contractual deliverables,
right?
And we're also asking for materials inventory, right? And then it goes through and says we're making a request for materials inventory, not a contractual demand, but a request, right? And it says we're asking for, please do this. I'm not saying it has to be read as an extra contractual request, but it could be read as either a contractual demand or an extra contractual request.
Your Honor, I don't think it's an extra contractual request when the government tells FEI you must provide an inventory in their letter. And that's a must. It's a requirement. And the way I read it, when the government tells me you must do this and it's referenced this contract, it's something required by the contract. And in the email, when they say submit the inventory no later than et cetera, the materials inventory was due on 31 December. Your Honor, I don't think it's a request. They're saying you had an obligation to give it to us. We demanded that you give it to us. You didn't do it by then. We're going to give you a little bit more time. And what Schedule 40 pipe, Your Honor, is, I didn't know about it either.
It doesn't matter.
It's big, heavy pipes, the plastic pipe that goes underground. And so, Your Honor, this is something that was submitted under the contract. The government was asking Mr. Dixon, go out there and do this. And Your Honor, the question was, and I'll get to data staff in a second, the constructor's case, Your Honor, which is Eighth Circuit, but it's a good case. And that case, Your Honor, does address this issue. And It says, quote, however, only certain professional supervisory work is covered by the Miller Act, namely skilled professional work involving actual superintending, supervision, or inspection at the job site. This cites Buttonhead at 535 F sup. Accordingly, plaintiff can only recover on the payment bond to the extent he performed on-site services. And Your Honor, he was performing on-site services on the date that he went out to do the materials inventory. And I would submit that reading his affidavit, it is physical labor. I mean, this is not something I could send my wife out to go do. She couldn't schlep around a bunch of Schedule 40 pipe and that sort of thing. So, Your Honor, I would suggest that that's it. On the issue on data staff, Your Honor, data staff is actually, it's a good case to contrast with this case, because in data staff, what the court noted was, it said data staff that was not lulled into a false sense of security that its claim would be paid instead because the subcontractor's claim was flatly denied by the surety. This is not a flat denial. This letter doesn't say your claim's flatly denied. What this letter says is you resubmit your claim, knowing that he's only going to have like 5 days to do this. After they sat on his claim for a year, they sent him this letter and they say, resubmit your claim. And they know it's going to take more than 5 days to get this done. Whether it's intentional or not, doesn't matter. Under humble oil, it's in Mr. Dixon's mind.
Can I ask you one final question
Sure.
as your time runs out? The district court described the February 8th materials inventory as a, quote, clerical task. Is that, and I understand you disagree with that, right? I'm not asking that. Is that a factual finding by the district court, and do we review that for clear error?
Well, I think you review that de novo, Your Honor, because
Why? Because he's describing what, there's testimony about what the inventory was, what was done, what wasn't done. I get you disagree with it, but why would I review that de novo?
Because we're on summary judgment, Your Honor. The trial judge didn't see any testimony from anybody. He looked at the same thing that Your Honor has in the record: affidavits, deposition testimony. Your Honor, it is a review de novo on a Miller Act case, and I just submit in this case, Your Honor, Mr. Dixon should be paid under the Miller Act. That was the purpose of it. Thank you very much for your time.
Thank you, Mr. Brown. We appreciate the argument of both counsel. As you know, our custom is to come down in the Fourth Circuit and greet counsel. But we'll have to greet you from the bench. We're still under restriction, at least for this term of court. So we hope when you come back in the future, we'll be able to come down and greet you in person.
Your Honor, I argued one of these just about a month ago by video, Zoom. This is way better.
We agree.
It just really is. Thank you, Your Honor.
Thank you. Prince George's County, Mr. Minelly. We're glad to hear from you.
Good morning, and may it please the court. I'm Tucker Mealy from Counsel Baradell in Annapolis, Maryland, and I'm here on behalf of the appellants in the case.
Counsel, it's up to you. If you would like to remove your mask to argue, you certainly can.
Thank you. If you don't mind, I will.
We can hear it a little bit better when you do that.
Forgot it was even on. As I was saying, I'm here on behalf of the appellants in this case, Chris Brzeznicki, Jeffrey Polk, and Thornton Mellon LLC. Mr. Brzeznicki is a resident of the state of Illinois and an honorably discharged member of the U.S. Army. Mr. Polk is also from Illinois and a seasoned tax sale attorney who regularly participates in tax sales throughout the state of Maryland. Their case concerns a challenge to a law enacted by the Maryland General Assembly.
Is the Thornton Mellon LLC, is that a cognizable plaintiff in a privileges and immunities case?
I don't believe that was addressed in the case below. I know there's some case law that talks about how if it's a corporation that doesn't have a cognizable claim under the Privileges and Immunities Clause, but I think with respect to Mr. Brzeznicki and Mr. Polk, they do. So I think that's always been the focus of the case.
Okay.
And their case concerns a challenge to a law enacted by the Maryland legislature, which discriminates against non-residents of Maryland by prohibiting them from participating in certain tax sales in Prince George's County. In 2017, the legislature amended Maryland Code Tax Property Article 14-817, which is one of the statutes governing the procedures by which counties in Maryland shall offer tax sale certificates for sale to the general public for delinquent real property taxes. The 2017 enactment added a provision, subsection D, which is only applicable to the Prince George's County, and it required that county to hold a limited auction before a main public auction. A limited auction was only open to certain categories of individuals, which generally included citizens of Prince George's County, those employed by the federal government or a branch of the Prince George's County government, or honorably discharged veterans. And then to close any loophole to a non-resident's participation in a limited auction, the General Assembly also amended Section 14-821 of the Tax Property Article to preclude the assignment of tax sale certificates from limited auctions to non-residents. Generally speaking, throughout today, I'll refer to this as the limited auction statute, if that's okay. Now, our position in this case is that the statute discriminated against non-residents.
Under the amended statute, the tax sales in question would be only those that relate to abandoned property?
Yes. So the original statute applied to all public auctions, and it was amended so that it now applies to abandoned properties. And they also essentially amended the provisions that Judge Massetti severed below and made it so that veterans had to be employed in Prince George's County, right, and federal employees had to have their offices in Prince George's County.
You have not made a specific claim under the statute as revised as opposed to the original statute. Is that correct?
Correct. The statute was revised after the decision was rendered. The state has raised an issue that the appeal is moot. I would contend that it's not, because for the case to be moot, I think that the amendment would have to substantially alter the statute so that the offending provision was no longer applicable, and the offending portion of the statute is still there.
How would you distinguish this case, say, from our decision in the Central Radio case, where the circumstances were somewhat similar and we determined to send the case back to the district court to determine in the first instance what the arguments would be under the revised statute?
And I don't have the facts immediately available to me in the Central Radio case, but I think in this case, I don't think that the amendment would change the analysis of the court below. The state certainly hasn't made an argument that the statute has been changed fundamentally, that the analysis of the court below would change. And I would argue for judicial economy, I think that it would be.
Is there an argument that your plaintiffs now can participate in the limited auction?
No.
Right. They are in the same position they were before,
Exactly.
right? That they are still prohibited. And part of that's because the remedy the district court granted here, didn't relate to your claim. Frankly,
this is I guess that issue is somewhat moot now because the statute has been amended in that regard. It's interesting because usually when you see a severance of a provision, it's the offending provision. And what the judge did was essentially sever the provision which made the statute essentially inconsistent with respect to.
Right. The part of the statute that undermined the state's stated rationale, he struck it as violating the Privileges and Immunities Clause, which seems quite odd, right? Because those were statutes that permitted out-of-staters to participate in the limited auction.
Frankly, it permitted Mr. Brzeznicki, my client, to participate.
Right. And so it effectively amended the statute to make it more protectionist.
Exactly.
But you agree that part of the decision is moot now, given that the state has adopted the rationale and also made the statute more protectionist than it was before.
Yeah, what the state did was he removed it completely as it concerns federal employees. Right. So to bring them back into the fold, they limited their participation to if they are working in the county.
Can I, and I'll turn it back, but can you talk to me a little bit about McBurney? And what I'm sort of curious about is why this case is not McBurney. I want you to help me understand why McBurney doesn't apply, right? And that's a case where it talked about whether the clear aim of the statute was a direct prohibition or restriction on a commercial activity. And I take your colleague's argument to be that this isn't that, and help me understand why their argument to the contrary is wrong.
Well, if we're talking about the first prong of the privileges and immunities analysis, you're not asking this. I mean, our first argument to that is that argument is waived.
Right. I want to talk about the actual merits.
You understand that, but we're talking about a common calling. Not that this is an argument, but they refer to my clients as investors. This is a profession, and we would argue that is one of the fundamental rights that was impacted. But as the judge found below, it's also the fundamental right of being able to acquire property.
So, what is the common calling that you're asserting, right? Because in McBurney, the plaintiff there asserted that his common calling was filing FOIA requests, right? And the court rejected that. And so I presume that Maryland here would argue that the common calling can't be buying tax liens. It instead is buying all property. And so you're not prohibited from buying all property because you can buy M&Ms at the grocery store, right? Well, so why is
the common calling, I think, is twofold. There's two aspects to this common calling. One is, my client is one of the largest they're one of the largest tax sale buyers in the state of Maryland, and they operate all around the country. And the way it works is that there's two ways that it is a viable business. One is that when you purchase a tax lien, there is a right of redemption. With that right of redemption comes.
So we're sure which of your clients is the largest buyer?
Well, I should clarify. Mr. Polk represents the largest tax sale buyer, and he participates in tax sales throughout the state of Maryland.
So he's an individual that works with a group.
Yeah.
And what they do is buy tax.
And even if they weren't, the way it works, or the way that it's a common calling, is that you invest in the lien, and it's not. I'm not sure how a FOIA request is a way of making a living, but in this regard, you buy a tax lien, and the owner of the property to redeem needs to not only pay off the lien, but also pay a high interest rate. And so it can be very profitable for people who invest in these tax sales.
So your argument is that Mr. Brzeznicki and Polk are in the trader business, the common calling, of acquiring these tax certificates at the county or city tax sale. Where in your complaint have you pled that either one of them had a common calling or a trade or business?
If I can address that on my rebuttal, so I can go through and address that.
I can tell you, I've read
Yeah,
through it and
yeah.
I don't see that you ever pled that.
Okay, and to the extent that it's required to be pled, I know it was addressed in our pleadings, our motions and responses in the court. And with respect to the second part of this is the acquiring of property. That's the second part is you can acquire property and sometimes at a lower than fair market value because you're paying, you're bidding on it and you can acquire property that way. So and I think that's what Judge Massetti focused on when he found that was the fundamental right that was impacted.
Let me ask you this question. I guess you would agree that owning personal property is a fundamental right. If that's true, why isn't this lien personal property?
It is, Your Honor. That's thank you. Yeah, it absolutely is personal property. It's assignable, and that's where 14.821 comes in. Is it's an assignable personal property right.
If we buy that argument, what does it do to your case?
Well, if what does it do to my case?
Yeah.
Well, again, I think that the issue was decided below, and I don't think it was challenged on this appeal. But I also think the judge was right, and I think that only bolsters our argument.
I got lost there. What bolsters your argument?
He said if acquiring personal property is a fundamental right, then if the statute is prohibiting my clients from engaging in that practice, then that would bolster our argument that the statute is discriminating against.
Right. Okay, I got you.
Do we think of? I just want to make. Do we think about those as different? I mean, oftentimes we think about a common calling like being a lawyer, right? And it's got a whole story. But an investor's common calling is the buying and selling of whatever it's investing in. I mean, it's a little bit hard to distinguish those two, isn't it?
A little bit, and Judge, I know you asked if we specifically say that they were engaged in a common calling. We don't say that, but we do say that we are engaged in tax sales, and we talk about what we do. So it's not explicitly stated, but I think it's inferred from the allegations. But it all is intertwined. I see I'm running out of a few minutes, so I just want to hit a couple other points, if that's okay, unless you have other questions about that issue. So the second prong is, I think, where the lower court got it wrong. Judge Massetti found that the aim of combating abandoned houses, encouraging home ownership was a worthy right, and I agree with Judge Massetti. I think it is, but that's not where the analysis ends. The next step in the analysis is you have to find that there's a substantial reason for the discrimination against non-residents. Put another way, are the non-residents the source of the particular evil that the statute is aimed to address? I think that
just to be clear, you think you got the first part wrong too, right?
No, I think he got it wrong in respect to disagreeing with us about a common calling. I don't take issue with the fact that he found that it was a fundamental right of real property. I don't disagree with that.
Is it? You just said it was personal. Is it real property or personal property?
It's both. I mean, it really is both. I mean, because the certificate is personal property, but then it converts to real property when you foreclose the lien.
All right.
But where he got it wrong in the second part is he found that the state interest is a valid one, and that's true. I don't think anyone disagrees that that's a valid interest, but he didn't find the nexus between the non-residents and the cause. The state essentially concedes this in their brief. They say the evil is abandoned houses. It's blight. They even say that tax sale purchasers, in some regard, perform a community service. In the cases that we cite, the Toomer case, the Hicklin case, the case with the Virginia bar case, they all involve. The court couldn't find any evidence that established a nexus between the non-residents and the issue that the statute was aimed to address. And there's simply no evidence in the record that was presented to support that finding. I don't think the judge even made that finding, but if he did it, I think he erred. Even the attorney general himself And this is what they cite as evidence in the record to support the statute. It's the Attorney General casting doubt on the statute in his memo to the governor. He's saying, there's a reason for, you want people to work in the county or live in the county where they work. Well, they took out the provision that requires you to be a resident or requires you to reside in the house that you're buying. So what's the connection? And then the other thing he pointed out was that before this, the tax sales were great. It was very successful. So there's really no evidence that shows that the non-state residents are the cause of any of the issues that the statutes aim to address. And I think that's the critical piece that's missing and why the judge should be reversed below. And unless you have questions, I'll reserve the rest of my time for rebuttal.
Thank you very much. Mr. Fine, we'll hear from you.
May it please the court. My name is Justin Fine. I'm an assistant attorney general with the state of Maryland, and I represent the appellee, Brian Frosch, the attorney general of Maryland. Section 14817D of the tax property article is a constitutional response to the blight of abandoned properties in Prince George's County. Under that law, the county's residents and certain people who work there have the first opportunity to purchase tax liens to abandoned properties because the people who live and work in the county have the greatest incentive to improve their community.
All right, can you stop there? So I understand you just said that, right? That like local people have the greatest incentive to develop. What is the evidence in the record that that's true? You might think it's like actually backwards, but just what do I look at to like substantiate that claim?
Well, first of all, under in the District Court of Maryland, there is case law, Sally v. Tax and Sale Investors, that community revitalization, community improvement is a substantial reason.
Oh, I agree with that.
Yes.
The question is, why are local people better at it than foreign people, aliens, to
non-residents? So
right.
Yes. Well, because they live there, they work there.
I don't want your opinion. This is no disrespect to you, right? Yes. Like you're a very smart guy. But I want to know what the evidence is for that.
Yeah, the record is thin in that regard, Your Honor. We have letters from delegates who supported the enactment, saying that this was an issue and we needed to promote residents to buy these properties.
Do they create this nexus between everybody says community redevelopment is great. Listen, I'm in favor of it. Nobody's against community redevelopment. The question is, why is non-development an evil being caused by non-residents?
So we have those letters in the record, and when the court is analyzing the second test.
Why are they cognizable evidence, though? I mean, those are just the opinions of some legislators. There's no factual, empirical evidence that I've seen that this thesis is correct. May very well be. But I don't see anything in the record that acts as proof as opposed to lay opinion.
Well, these legislators, they're legislators, so I would say that they're more than just lay opinion. They're politicians and lawmakers. They live in the county. They represent their residents.
You're pandering to Judge Agee, right?
And not only that, but the court, when it's considering the substantial reason and the nexus, it grants considerable leeway to governments in analyzing local evils and prescribing appropriate cures.
I mean, have you heard the term NIMBY? Like not in my backyard?
Of course.
Have you ever heard of local government group or local nonprofit groups or local individuals opposing development in their community?
Well, I have, but this case.
And so the question what I'm sort of getting, I don't know whether NIMBY's right or you're right? That local people want to tear down houses and build multifamily housing, right? That might be true, might not be. I don't know. But what I can't tell from the record is why we should suggest the idea that NIMBY doesn't exist, and instead the most pro-development people in Prince George's County are their residents.
The difference here, Your Honor, between NIMBYism and selling tax liens to abandoned properties, which under the law are immediately foreclosable because it's expected that abandoned owners aren't going to redeem them. The difference is that you purchase a tax lien with that right to immediately foreclose, whereas the professional investors in this case, they buy those liens not to develop or redevelop or purchase the property. They're in this case to have the owner redeem the tax lien and then pay the investor above market rate interest rates, fees and interest.
That's their ambition. I mean, they don't know till after they bought the certificate.
Well, they do in some ways
whether or not that's going to happen.
Well, I think the record actually does show that the professional investors do a substantial amount of research. They look at the properties. They do take a risk. They don't know if it's going to be redeemed or not, but they're very careful in selecting the properties that they're going to bid on based on their belief on whether or not the owner is going to redeem it. Because that, as a professional investor, is how they make their money. So I think that is the difference here between, say, NIMBYism and development and the sale of a tax lien to abandoned property in particular.
Is there record evidence that suggests that professional investors don't buy vacant land in tax liens?
Vacant or uninhabited or no, but as a matter of practice.
Yet you're saying it, right?
It's a matter of, yes.
I understand you're saying it and you're saying, oh yeah, but these guys, they wouldn't dare buy vacant land because investors don't buy vacant land. But we sort of know that's not true, right?
Well, the record reflects that, and it's been raised in the
Where would I find that in the record that investors do not buy vacant land?
We made that argument in our response brief, and it certainly wasn't contested. And so they could, but that's not how these investors make their money.
And the best site for that is your response brief.
Correct. When we describe the general process, and the record evidence is the practice that
Nobody testified to that.
Correct.
So your response seems to be a pretty strong argument to acknowledge that what the plaintiffs and folks like that do is a trade or business, a common calling.
The Attorney General has never said that tax sale investing is not a job or profession, but what the issue is under the analysis, under the first prong, is that the statute, section 14817D, does not restrict a common calling or profession in any way. That's what's material.
Well, if you're not a resident of the county and you do that, whether it's a hobby or that's your vocation, you're unable to practice it at these limited auction sales in Prince George's County, simply because you're not a resident.
Well, earlier, the court mentioned the McBurney case, and under that and the court's precedent, it's clear that in order to offend the Privileges and Immunities Clause in terms of a common calling, the statute on its face must directly prohibit, restrict, or regulate a certain profession or trade. And that's not what section 14817D does here. And moreover,
I don't understand that at all, right? You're saying, I think you agree, as you got to, that buying tax liens is a trade or business. Yeah. And your statute says, if you don't live here, you can't do it.
But it does not say, it does not mention any profession or trade, and that's what's required, and that's what McBurney was about. The statute, the FOIA statute it issued.
So in other words, if it says you cannot sell hats in the state of Maryland, but it doesn't mention the profession of being a hat seller, which is maybe a haberdasher, I don't know, whatever it is, like that can't be, right? If you prohibit what somebody does, that is the direct prohibition of the trade. That doesn't make any sense to me.
That's my understanding of McBurney, is that merely incidental effects, limitations on a profession is not enough to violate the Privileges and Immunities Clause.
No. So help me understand, why do you think that's what McBurney says is when you're not directly addressing commercial activity, right? So it's FOIA, then we have this question about, is it still commercial in spite of that? But McBurney specifically doesn't apply where the regulation itself is of commercial activity. I mean, the point of McBurney is that FOIA is not itself a common calling or trade or business. right? But you agree that the buying of tax lien certificates is a trade or business, right? So McBurney doesn't apply because it's addressing non-commercial activity. And this is a case that the whole regulation is about the buying of tax certificates.
I don't understand McBurney to the opinion to say that obtaining FOIA and obtaining certain information was not a profession. But again, it was that defining you must in order to offend the Privileges and Immunities Clause. One of the things it must define a trade or profession at a high level of generality. So in Toomber, we're talking about commercial shrimp fishing. In Hickland, we're talking about oil and gas development. In the United Buildings case, we're talking about contractors who perform public construction. So I think when the appellant in McBurney tried to say, well, it's limiting my profession as a FOIA investigator, that was kind of a self-serving, narrow description of their job that the court didn't buy, and the statute didn't limit that. But what I would say that before we even get to—
Isn't that because, as Judge Richardson indicated in his question, the FOIA statute in McBurney is one of general application. Anybody in here can make a FOIA application about just about anything that relates to the government. But it was the incidental effects that were referenced in McBurney that you just happened to have an individual who had found a commercial application for the FOIA statute that was atypical of any other FOIA application. But here, the buying of these tax certificates seems to be in its essence a commercial activity, whereas making a FOIA request is not.
I'll respond by saying, well, in an initial matter, the prohibitions in the Privileges and Immunities Clause are not absolute. So that's why some incidental limitation on a profession or trade, without directly mentioning that, is acceptable under the Privileges and Immunities Clause. But we don't even get to the first and second analysis under the Privileges and Immunities Clause in this case, because in this case, we're talking about the government's own commercial conduct. And the Privileges and Immunities Clause does not apply to the government's own commercial activity.
Right, so United Buildings says that's wrong, right? It says the market participant exception of the Dormant Commerce Clause simply does not apply to the Privileges and Immunities context.
It said it would.
I don't. So I mean, help me understand that. Like you said, if they're doing something commercial, it doesn't count, right? And that's what the market participant exception is in the Dormant Commerce Clause. And United Buildings says no, that does not apply to the Privileges and Immunities because they got totally different purposes.
What United Buildings said was that it would not mechanically apply from the Commerce Clause that particular market, private market, public market distinction. But what it did say was that there is a qualitative difference between public employment and private employment. So there is a distinction there to be recognized under the Privileges and Immunities Clause.
Right, at the second step, right? What the court's talking about in United Building and Hickland is the second step, right? If it's protected, does that discrimination violate the clause? Because we know, as we talk about the seventh step here, differential treatment can be justified. And we look at a variety of factors to do that. And that's what Hickland and United Building are telling us to do. And if it's government property, right, that might help provide a substantial reason. And we can then evaluate whether there's a close relation. I get all of that, but that's not at step one, which is whether it's a protected interest.
Well, it is step one, and that's under the decision, City of Salem. And granted, it was by the Third Circuit Court of Appeals, but it borrowed from United Building and that difference between public and private conduct to reach that decision. Essentially, what it said was there was no fundamental right to public employment, direct employment by the government, and so by extension, there is no right to buy a tax lien directly from the government. And the government can limit.
If that's true, so let's just take that for just a second. If that's true, doesn't that mean that United Building is wrong? Because if there's no fundamental right at step one to ever do anything with the government, then not only do you have a market participant exception to the Privileges and Immunities Clause, but it's stronger than the market participant exception that applies to the Dormant Commerce Clause. The point of all of that is it has to be step two, because if it's a categorical step at step one, then United Building's suggestion that it's not a mechanical application is nonsensical.
One of the reasons why the United Building and City of Salem in particular is applicable here, because a key distinction in those cases which talked about public and private employment in this case is we're talking about essentially tax collection, and tax collection is a quintessentially governmental function.
But it's not tax collection, right? But it's not tax collection because the buyer of the lien is making the state whole, right? That's the tax collection. The tax is now collected. Any money that is then collected is a reimbursement to the investor, right? They're not an agent of the state, right? This is just like Piper. We don't think of lawyers as being agents of the state. The buyer of a tax lien is no more of an agent of the state than a lawyer is in Piper, right?
They are, yes, but they work directly for the state. And again,
no, why do they work directly for the state? They just bought something from the state. Whatever they do, whatever decision, they make their own decisions, their own judgment about what to do. And whatever they succeed in getting goes to them, not the state. The state gets nothing more after they have sold the lien.
Again, I fall back on the distinction here that it's not tax collection, but I believe that it is, and that is an important distinction in this case. So if we get to the second part of the privilege and immunity clause analysis, and if the statute here burdens a fundamental right, the privileges and immunities clause tolerates some discrimination against non-residents if there's substantial justification. There has to be substantial reason, and the degree of discrimination must bear a close relationship to that reason. As an initial matter, the appellants, the investors, have waived any argument about the substantial justification of the 2021 version of the law, because in their opening brief, they only discussed the 2017 version. They didn't talk about the amendment to the limited auction, where it only included abandoned properties, and they certainly didn't discuss the narrowing of veterans and federal employees. So by failing, and they talked about the wrong statute on appeal. So in terms of substantial justification, for all intents and purposes, there is no argument against that in terms of the 2021.
How did the substantial reason change with the revised statute? It became more protectionist, right? It said we want to keep more people out of the trade and business of buying tax liens.
I disagree.
So tell me how it became a different substantial justification.
Again, they didn't address it at all, so it just simply is a nullity.
Maryland, I agree. It doesn't appear that Maryland addressed it at all, but that's what I'm getting at.
I meant the appellants didn't. They didn't address the 2020. So the reason why it's actually less protectionist, and again, it's because only tax liens to abandoned properties are sold during that initial limited auction. So
but they're a subset in the amended statute of what the original statute covered. Is that correct? So abandoned property was covered under the original statute, even though other properties were included. And then the later amended statute, even though it's limited to abandoned properties, they always have been included.
There was never a distinction. That's correct. So under the 2017 version of the law, any and all properties, the tax liens to any and all properties were sold during that limited auction. Subsequently, only tax liens to abandoned properties were sold during that initial limited auction. So I don't think there was a distinction made about abandoned properties in the old law. But now it's front and center. That's what comes first. And for a professional investor who's not really interested in buying those tax liens anyway, because there's a little to no chance of redemption, how is that offensive or discriminatory against them? They still have the right to participate with the rest of the general public to purchase the most lucrative tax liens. And of course, Your Honors don't have to address any of these arguments if it finds that the 2021 amendments to the law have mooted the investor's appeal. And Your Honors earlier cited Central Radio, but I believe Jordal versus Democratic Party of Virginia actually.
So why would it have mooted the appeal if the abandoned property was included in the first statute and it's still included in the second statute?
So Jordal has several principles that answer your Honor's question. And first of all, is that as applied challenges to which we have here to a newly amended statute are premature. There's simply no record here, and there was certainly no argument in the reply brief about why or how the investors will be harmed going forward under the new statute.
That's sort of the central radio argument. Isn't it?
Sure, and so those two are copacetic. The other point, and there's three that I'm going to make in total, is that there's no evidence of adverse effects on the new law, and simply past exposures to harm does not present a live controversy.
Do you represent that all of the plaintiffs in this case can buy at the limited auction under the new law?
I believe none of them can.
Right. Okay. Thank you. Sorry. I thought you just said there was no adverse effect on them by the new law.
There's no evidence of any adverse effect. They certainly haven't argued that under the new law going forward they can't. And the last thing I'll say is that although the residency preference is still in the law, it is no longer offensive to the appellant investors, and that's again because of the low desirability of tax liens to abandoned properties. So, in conclusion, the Privileges and Immunity Clause does not apply here, and if it does not impair a fundamental right. It is substantially justified by the legislature's goal of community revitalization. Therefore, the court should affirm summary judgment in favor of the appellees.
All right. Thank you, Mr. Fine. Mr. Manili, you have some rebuttal time.
Thank you, Your Honors. First, I want to just unpack a couple of the arguments that were made. I'll point the court to page 24 of our opening brief, subsection 4 of that argument, which says that the Maryland legislature's amendment to the statute did not render it constitutional. We absolutely did address the amendment, and we argued that it didn't make it, it fundamentally changed the fact that it was discriminating against non-residents. Our case is that the statute's discriminating against non-residents. There's nothing in our case that says that it's discriminating against out-of-state investors. Although that's part of what our clients do, they're non-residents and it still discriminates against them. The other thing that's interesting about their argument, again, and there's just nothing in the record to support it, and they cite none, is they say, well, it's not offensive to investors because they don't want abandoned properties. Well, doesn't that concede the fact that the investors aren't a cause of the harm that the statute's trying to address? But taking it a step further, the statute doesn't change anything fundamentally about what was discriminatory about it in the first place. You asked the counselor, are the plaintiffs allowed to participate? He said no. That's why it doesn't render it unconstitutional or constitutional. With respect to the fundamental right, in the brief they were making an argument that the out-of-state tax sale buyers are essentially equivalent to like a public employee, working as an agent of the government. And I just don't think that's a fair analogy. I don't think there's anything in the record to support that. They're participating in a transaction with the state. State's getting paid the tax, but they're not working for the state. They're not getting employed by the state. There's no employer-employee relationship or anything like that. There's not even a independent contractor relationship.
So your position is that the public employment line of argument, whatever it is and whatever the merits of it, simply doesn't apply to a commercial transaction, because the Supreme Court has repeatedly told us that the nature of that public employment relationship is different from a standard commercial transaction.
Yeah, well, and also just that's just not what it is. So you can't really look at those cases. You can't apply that analysis if that's not what the circumstances are. With respect to the amendment to the statute, again, the fundamental problems with the statute and what makes it unconstitutional hasn't changed. So I don't see any basis to send it back or to render the appeal moot because, if anything, the statute is even more restrictive than it was when my clients filed their lawsuit. Judge Massetti, when he's, and if there was no amendment, we would be arguing that what Judge Massetti did was essentially making it more restrictive and not correcting the offensive part of the statute. So in closing, it's a low bar. I mean, I'll admit it. It's a low bar to establish that there's a substantial reason for the discrimination against non-residents, but it's still a bar. You have to have some evidence, and there is just no evidence. I understand that they've cited testimony of legislators and a letter from the Attorney General, which I would say is more in support of our argument. But you'd ask, there's no evidence of, any kind of numbers that show that when out-of-state tax sale buyers purchase a house that goes to foreclosure, that the property remains abandoned or that it contributes further to blight. There's just no evidence of that. And I think even in the record, when it talks about the tax sales, obviously by its very nature, the participation is more limited. And so I think more money is generated when they have it open to more people, which frankly is better to, it might be different now because it's only for abandoned properties, but it certainly generates more surplus proceeds for the homeowners to the extent there are proceeds. So in closing, we would ask the court to reverse the lower court and order that court to enter judgment in favor of the appellants.
Thank you very much.
Thank you very much.
We appreciate the argument from both counsel. We're still under limitations as to what we can do after arguments. So our tradition of coming down and shaking hands is still not restored. So hopefully the next time you come back, we'll be able to do that. So with that, I'll ask the clerk to declare a brief recess while the attorneys change, and we'll be back shortly.
Your Honor.
Mr. Theuer?
Thank you, Your Honor. May it please the court. My name is Jim Theuer. I'm the counsel for the appellant, Mr. Arce. This matter comes before the court from the verdict after a bench trial, finding my client guilty of counts of receipt and one count of possession of child pornography. The issues on this appeal are laid out in the briefs, and I just want to touch on what I think are the highlights and answer the court's questions as I do so. The first issue is related to custodial interrogation of my client that was used at trial. It was the subject of a motion to suppress that was denied. And we briefed this issue, the government and I, and we have addressed in many respects the same cases. We rely on Hashimi and Kalana. Government relies on Hargrove. But I think it's important to look at the similarities between the two and what Hargrove distinguished. Hargrove distinguished the fact that in that case, the defendant was not under constant armed guard and escort, and the interrogation did not occur in a law enforcement vehicle. Well, here, it's undisputed that the interrogation did occur in a law enforcement vehicle, and Mr. Arce was, in fact, under constant armed guard and escort for approximately 2 hours, the duration of that encounter. He was requested to go to the vehicle. The woman who was there with him in the house, she was ordered not to speak. They were ordered not to speak to each other. And there was a flood of officers into the house. It was 14 officers from 3 different agencies, as well as additional uniformed officers outside. So we think that our fact pattern is much more similar to Hashimi and Kalana than it is to Hargrove.
Well, absolutely. In cases like this where there were post-warning, warnings were given after statements were made, was there any evidence presented of coercion?
Our evidence of coercion, Your Honor, is the fact that it was in the law enforcement vehicle. Those warnings, the Miranda warning was given 25 minutes after the interrogation started in the vehicle in which Mr. Arce was in the front seat with 1 officer in the driver's seat and 1 officer immediately behind him. We think that is the custodial nature, the coercive nature of the interrogation, in that he was asked to go to the vehicle away from the kitchen where Miss Farmer was. Again, that's an important fact when you look at Hargrove's facts. And within that context of that interrogation, that's when the Miranda warning was given after incriminating statements had been made.
Well, can we find that in circumstances like this that the officers mistakenly failed to do it? They didn't do it purposefully. Can we make such a finding?
I believe it's fair to say that the evidence would be that they didn't purposefully not give him the Miranda warning before they took him to the vehicle. But that is not dispositive. When you look at the Kalana case, there were in fact warnings given, and yet this court found that the interrogation was custodial, coercive, and therefore the warnings didn't cure the coercive nature of the interrogation. Similarly in Hashimi. So I understand the court's point, but I think that the case law that the Fourth Circuit has developed over time is that even if you have prophylactic warnings at some point, those alone do not cure whether the statement was knowing and voluntary if it was equally accompanied by or overwhelmed by factors that showed coercion.
Can you go back to the sort of maybe the question that comes first that I've struggled with a little bit, which is this isn't his home, right? And so we've sometimes talked about in the car cases, for example, that the driver of the vehicle sort of has some feeling that he has to stay with the vehicle. And you might say the same thing about the resident of a home. Like if they go to your home, you may feel less freedom to leave. But where he's invited, and this is not a standing question, but just from a freedom to leave perspective, then it seemed to matter that this isn't his home, and that, you know, the officers, at least when they showed up, had no reason to think that he was involved in the criminal activity. He would not have, you know, at least an innocent person in his shoes would not have believed that they were there to get him. Like all of those things seem to me to suggest, unlike the cases that you cite, which are all about going to the defendant's home that everybody knew was the target of the investigation. He's not the target of the investigation. This isn't his home. He has somewhere else to go, right? Unlike if it was his own home. Don't all those cut against the idea that he was in custody?
Your Honor, I would disagree that they cut against it for this reason, that he is house sitting for his sister and brother-in-law, and he is in charge of their dogs. So he has responsibilities to not only the property, but to the animals in the house. So it's not a question of him simply abandoning the animals.
Totally fair. But the question of whether he's in custody is whether law enforcement creates a need to stay, right? Not whether his love of his canine friends creates an obligation to stay, right?
Yeah, but Your Honor, the facts here, I think, are clear that it's the agent's own testimony that they asked him to go to the car. They asked him to go to the law enforcement vehicle. They didn't say to him, he didn't volunteer to go to the law enforcement.
Cuff him and drag him there either, though, right?
Correct.
But those are all different from the question I'm asking, right? And maybe you say it's not enough, but you say it doesn't weigh at all the other way, that this isn't his house, that he's not the driver of the vehicle, is the sort of analogy that I'm looking at. You think that doesn't cut against the idea that this was a custodial situation?
I think it's a factor, Your Honor, but that's what the court looks at. It looks at the factors. And
so what I'm asking is, do you have any cases that address that factor? That's what I'm looking at. I think it's a factor too. I'm glad you acknowledge that. But what I'm trying to get at is, when I look at our cases, I don't see a lot of development of that factor and its relevance to determining the custody question.
Your Honor, I am not aware of a case that addresses that issue.
Thank you.
To continue into the search of the Caribe place where the Alcatel phone and the ZTE phone were located, I would simply point out that in the cases cited by the government in their brief, you did not have this fact pattern where you had a custodial interrogation and it was a continuous process from the interrogation to the search of the location of the apartment. And we believe
he gave consent to go there, correct? He even showed him how to get there.
Absolutely, Your Honor, I agree. And so the issue that we've raised for the court is that consent coerced? In other words, is it part of a continuous process? And I recognize that I'm asking the court to find that if it's not coercive in the vehicle at Lord George, I'm going to have a very difficult time convincing you it's coercive in the parking lot of Caribe Place. I recognize that my argument depends on a continuous movement, a continuous custodial interrogation that began when they took him to the SUV in the driveway of Lord George, and it continued thereafter through into Caribe Place.
There's no other evidence other than this continuum concept that there was conversion at his apartment.
The only other factor that I would point out for the court is the issue of the threat of a search warrant and the threat of harassing his brother, who's in the Navy, who was down in Florida. And I would simply point out that those two are factors.
The brother who owned the house?
Yes, Your Honor, his brother-in-law. The brother-in-law and sister, that was their house. And I would note that Hummer, which is a case cited by the government, talks about how those two are factors that this court should consider in determining whether consent was voluntary to excuse the warrant requirement. Or
did the district court find that there was a threat of a search warrant?
Frankly, Your Honor, I don't remember if the court relied upon that. What the agents did testify was that they did say that they would simply get a search warrant if he did not consent. So that was undisputed evidence at the suppression hearing.
Of course, he could have told them to get the warrant.
I'm sorry, Your Honor, I didn't hear.
But he could have told them to get the warrant.
Agreed, Your Honor. He could have told them to get the warrant. But again, the Hummer case shows that that is a factor for the court to consider as to whether the consent was in fact knowing and voluntary. It's not dispositive. It's simply another factor. And we think that the overall circumstances, with the totality of the circumstances test, when you look at the fact that it's a 2-hour continuous interrogation, 2 hours in custody, there's no break, there's not the vehicle, then he's back in the kitchen and he's talking to his friend, Miss Farmer. agents are doing whatever it is they want to do. Farmer and RC are doing whatever they want to do. And then they say, oh, by the way, why don't you let us go to a Caribe place and consent to a search? We don't have that. We have, let's go to the car, interrogation in the car, let's go to Caribe place from the car. And we think that's a factor that's important. I've also raised a number of issues on evidence that was allowed into the trial of the matter, and I want to point them out very briefly. First of all, we made an argument in our brief that the expert report, Exhibit 26 and Exhibit 6, which is the summary of that report, is testimonial. Why? Because the agent Montoya testified that he ran a Celebrite software against it to create the report, and then he ran it through a Griffi software that would characterize the images. And on direct, he was asked about that, whether he created the report using Celebrite and Griffi, categorizing different things you found, and he answered yes, and that's at 612 in the record. That's testimonial. Griffi is testimonial. It's characterizing files as either child abusive material or child erotica. And the government makes no argument against that issue. They don't argue about the testimonial side of it. They simply focus on the Rule 52 issue. On the Rule 52 issue, have the same issue there in that expert reports are hearsay. They are not admitted into evidence. You cannot have an expert get up there, testify to whatever his or her opinion is, and then introduce his or her expert report into evidence for the trier of fact. It's hearsay. There was no stipulation to permit it, and the court erred in allowing that in. On the lay opinion.
Before you get off that, so I presume what you're saying here is that the characterizations is what's hearsay, not the Cellbrite dump itself is the actual evidence, right? But the characterization as being CP is the hearsay piece or confrontation clause problem.
Correct, Your Honor.
Okay, so tell me why that's not harmless, right? That characterization, the judge had them, was able to view the images. These were not images that were like close calls one way or the other. And so in that scenario, why is that characterization, if we assumed it was improper, why is it not completely harmless, given that the judge was able to view the CP itself?
Well, here, Your Honor, the government doesn't even make any attempt to prove that the confrontation clause violation beyond a reasonable doubt did not contribute to the verdict. I mean, that's the standard,
do, right? I mean, or at least maybe I read it wrong, but I read them to say that because the images themselves were seen by the district court, the trier of fact, that the district court could conclude that they were CP merely by looking at them. That it did not require expert opinion, and Griffin Eye's match was unnecessary, and therefore its inclusion was harmless.
But the issue, Your Honor, is those images don't go to the trier of fact, except that Griffi characterized them as child pornography.
No, but they come on the Cellbrite. The whole Cellbrite went. Exhibit 26 is the whole Cellbrite.
Your Honor, there were 14,000 images on that Cellbrite report. In other words, you take the Cellbrite is, as you characterize it, is a data dump, and it simply dumps every file into a chart. The characterization by Griffi pulls out.
Well, right, but that doesn't change the calculus here, right? Because if the agent did it behind the scenes and said, here's the dump of 14,000, right? I pick out these 5 because these are the ones that match Griffi. And then I put them into evidence, but I make no characterization of them as an agent. None. I just put them down and say, these came off that phone. And that's not hearsay. That's just evidence. Then the judge looks at those and says, that's CP. Right? The trier of fact says that's CP. I can look at it. Right? Why isn't that the harmless error chain that we're describing?
Your Honor, because the government has to prove beyond a reasonable doubt it didn't affect the decision. And what you've described there, Griffi has characterized it. Griffi has testified it's child pornography. that would be the same as if an expert went on the stand and simply, an expert didn't go on the stand. An expert report was simply submitted. Here it is. Here's the child pornography trier of fact. Now you can look at it. I see that my time is up, Your Honor.
Can you just answer that question, right? So why isn't that okay? Right? It doesn't work for a drug chemist, right? Because the judge presumably can't test the substance, right, on the bench, right? The trier of fact can't test the drugs. But child porn's not like drugs, right? So child porn, we can look at it, at least in the most extreme examples, which is what we've got here. We can look at it and we see what it is. We don't need expert testimony to tell us that that is a child.
Well, Your Honor, I will say this. On the four image files, the thumbnails that supported the receipt counts versus the video file, I think it's a leap to say on the video file that it is patently obvious without the use of expert testimony that every image is child pornography. And without getting into the details of those video files, but
that's your point is that no, without the expert testimony, it is not beyond a reasonable doubt that somebody would necessarily conclude that these are CP. And if I disagree with you on that, then you lose on harmless error.
Yeah, that's right, Your Honor.
I just want to make sure I understand the framework. Thank you.
You don't have to answer this right now, but I'd like when you get back up for you to focus on the lifetime ban on the accessing the internet.
Thank you, Your Honor. I will.
All right. Thank you very much, Mr. Stewart. You have some rebuttal time. Mr. Sheehan.
Good afternoon, Your Honors. May it please the court. My name is Daniel Sheehan, and I represent the United States in this case. This court should affirm the district court's convictions and sentence of Mr. Arce for receiving and possessing child pornography. There's obviously 5 issues. In this case, I'm going to start first with the first issue that Mr. Thor addressed in the district court's denial of Mr. Arce's motion to suppress. There was no violation of the Fifth Amendment in connection with the interview of Mr. Arce by the law enforcement officers. And looking at the totality of the circumstances in this case, it is clear that this case is much more akin to the facts presented in the Hargrove case and is really worlds apart from the circumstances presented in Hashimi and the Kalanick case. And Judge Richardson, you made a very good point that we would emphasize as well that it does matter that this house did not belong to Mr. Arce. The court has to look at it from the perspective of an innocent, reasonable person. An innocent, reasonable person who's confronted with law enforcement officers and is told they have a search warrant to search that house. That's not his house. So that does and should factor into the court's analysis and determine whether there was a custodial interrogation. Another big...
Counsel, am I remembering correctly, in Hashimi and the other case you cited, the officers came in with their weapons drawn?
Absolutely. A large team of agents came in with their weapons drawn and essentially pulled those defendants out of bed and ordered them downstairs at gunpoint. In this case, we know it's undisputed. There weren't any guns drawn at any point. Mr. Arce was never handcuffed at any point. It was 2 plainclothes officers who had on bulletproof vests who came to the door. They didn't barge in. They didn't knock it down. They just knocked on it, and it was Mr. Arce who came to the door. The dogs were going crazy in the background, so he asked if he could go let him out. And the agent said, sure, go ahead. So he did that, and then he came back. And then they found out another woman was in the house, his friend, Miss Farmer, and she was upstairs. They didn't run upstairs and pull her out and put her outside. They just called for her to come down, and she did. And they proceeded to explain to her that they were there to execute a search warrant on the house and explained to them that they weren't suspects in the case, but they did need to search the premises. And from there, they asked Mr. Arce if for his own individual privacy's sake, if he would go speak to them in private outside in an unmarked police car. So that's why they left the house to speak with him and have a private conversation. It's important to also consider the fact that once Mr. Arce entered the car, he wasn't put in the back like a suspect would be. He actually sat in the front right next to Detective Simpson, who was questioning him. And the other agent sat in the back and wrote notes on what Mr. Arce was saying. He wasn't handcuffed at that time. The doors weren't locked. It wasn't a special vehicle that prevented somebody from exiting. And most importantly, at the beginning of that interview in the car, they emphasized to him that, he wasn't under arrest. He didn't have to answer their questions, and he was free to leave. And the entire encounter from both pre-Miranda and post-Miranda in that vehicle was at most 1 hour. In the Kalana case, it was 3 hours. So this case is just far apart from the circumstances that were present in Kalana. And to move on to the issue of consent, I mean, there's no question that the district court got it right that Mr. Arcee's consent was knowing and voluntary. The district court had the opportunity to see Mr. Arcee testify at the motion to suppress hearing and made the conclusion that he was educated and intelligent. He was 29 years old. Judge Richardson, to answer your question earlier, the district court did note in its opinion that the officers explained to Mr. Arcee that he had the option of either consenting to the search or that they would go and apply for a search warrant, but the district court did drop a footnote and cited this court's precedent, which explains that factor is not dispositive. The fact that a search warrant or the possibility of a search warrant is mentioned doesn't invalidate the consent, and that's certainly the case here. Mr. Arcee also memorialized his consent in writing. Before they went in to search the apartment, he signed a written consent form. After they went in, one of the agents initially found the ZTE phone, and it was Mr. Arcee who actually said, no, actually, there was another phone. The phone I told you about earlier was the Alcatel phone. That was under my bed mattress. So then the agent went and got that and brought it out. And after they left the apartment, Mr. Arcee signed the consent form affirming again that he consented to them being able to search the Alcatel phone and the ZTE phone. And not only did he do that, he provided the swipe pattern so the agents could get in without any problem. There was no evidence of any physical or economic threats by the agents to Mr. Arcee at all. So the district court got it right with respect to both the Fourth Amendment and the Fifth Amendment. To move on to the district court's evidentiary rulings, Judge Richardson, again, I think you touched on a point that the government has made in its brief. First is that the categorizations by Montoya, they didn't violate the confrontation clause. They didn't violate the hearsay rule because Montoya himself testified that irrespective of Griffi, he analyzed all those images and made the call that they constituted child pornography.
Yeah, but he did so based on his training and experience, right?
He did, that's correct.
Right. And that's expert testimony, and you didn't offer him as an expert. Right? As soon as you say, I mean, you absolutely could have offered him as an expert, right? And he could say, based on my training and experience, that's a kid, right? The problem is, like, that's not what happened, right? So he testified based on my training and experience, which is expert, like red flag, this is expert testimony. And then put in a report based on Griff and I without, being qualified to talk about whether Griff and I was reliable or not, or where it came from, or why he relied on it, which he could only do if he was an expert. I'm having trouble understanding your argument. I get the harmless error argument, but I'm having trouble understanding the argument that it's not confrontation clause, hearsay problem to put in the Griff and I identification as part of his, Exhibit 26.
Well, Exhibit 26 was just a Cellbrite report, which is essentially just a dump of all the information that's on the cell phone.
Except what? Except it included an identification, a characterization of certain images as being CP. That's not Cellbrite, right? That's Griff and I. And what's Griff and I? Griff and I is like a law enforcement database where, like, people have determined based on their training and experience that these are child porn based on hash values. Viewing them, comparing hash values, all that's legitimate, right? But that's the judgment that's being made here. And you put that in, I don't mean you personally, but you put that in without an expert. And it is the conclusion that's not Cellbrite itself, but is instead that characterization that's the problem.
2 points on that. The first is that Montoya himself did make the characterizations. The record is clear that irrespective of Griffi, he reviewed those images and made the call that they constituted child pornography. The second point I'd like to make on that is under this court's precedent in the Smith case, it says if a witness could be introduced under 701 as a lay opinion witness or could be qualified and introduced as a witness, an expert witness under 702, it's essentially harmless error. We took the position at the trial court that Mr. Montoya's testimony did not rise to the level of expert testimony, but we did disclose him to Mr. Thur in advance of the trial, and he was aware of him, and the record reflects sufficient qualifications. If the court wanted to qualify him as an expert under 702, certainly there was information that the court could rely upon
Court
to
doesn't
reach
do
that
that. The
conclusion.
government does that, right? The government moves to qualify somebody as an expert.
We did not believe at the trial court level that that was necessary, but at this level, the court can look at it from a harmless error perspective and saying his testimony, if it wasn't good under 701, it was at least good under 702 because the record establishes all of his qualifications to do that. And then on top of that, related to our harmless error argument, as you got to earlier, essentially it's the district court's call to make as the trier of fact. So irrespective of what Montoya testified about, it was ultimately the district court's call to determine that those images that were at issue in the indictment constituted child pornography. And that wasn't really at issue or disputed at all. So it is harmless error if there's any error at all. With respect to the sufficiency of the evidence, we made the argument that Mr. Arce has either waived or forfeited his challenge to that, such that this court's review should just be limited to determining whether there was a miscarriage of justice. But even if the court looks at it from a de novo review perspective, it's not even a close call. There was abundant amount of evidence pointing to Mr. Arce's guilt and supporting the convictions of him for both receipt and possession. The first, of course, was Mr. Arce's confession that he indeed downloaded and looked at child pornography on the internet using a specific file sharing application called the uTorrent application. He told the agents that he was familiar with very specific search terms that are associated with child pornography. He'd been looking at child pornography over the last 1 to 2 years and actually had most recently looked at it in the past 2 to 3 days. And that information is important because it was corroborated by the government's forensic examination of the cell phone, which showed, number one, he had the uTorrent application on there. Number two, he had looked at and received images in May of 2018, which was the same time frame that the search warrant was executed. And he told the officers that he'd been looking at the child pornography in the last 2 to 3 days. And of course, it wasn't just the images that were named in the indictment. It was 347 images in total and 3 videos that constituted child pornography, as well as the web history that came up from the Alcatel cell phone, which matched some of the search terms that he told the officers that he was typing in when he was looking for child pornography in the first place. On top of that, you also had the forensic examination of the 2 other electronic devices. There was the ZTE.
Maybe you want to turn to the supervised release issue.
Okay, yes, Your Honor.
Like why do we think? And admittedly, our case law has recently been evolving here, but why should I find that the district court did enough, given our recent case law on the lifetime internet ban, to take what I think is your hardest case? But maybe the district court could do enough, but why do we think, with the benefit of hindsight, the district court did enough given our recent case law on that issue? Or is that something that you acknowledge sort of needs to go back?
We don't acknowledge it needs to go back, Your Honor. We think that under the 3-pronged test that this court set forth in Hamilton, the district court's analysis is sufficient. The first factor the court has to look at is whether the defendant used the internet to commit the offense. Obviously, that's the case here because Mr. Arce downloaded uTorrent and used the internet to look at child pornography on his cell phone. So that first factor is satisfied. The second factor that Hamilton emphasized.
2 of the supervised release provisions under special conditions 7 and 15, I don't believe the district court gave any justification for.
The district court, Your Honor, did give a specific justification related to the restrictions upon access to the internet and access to minors, and specifically said that those conditions were because of the offenses of conviction. And a lot goes into that term, the offenses of conviction, because prior to getting to that point, the district court went into an extensive analysis of the offenses of conviction and what, the nature and circumstances of Mr. Arce's offenses entailed. She also said it was because of the lies that were told to Detective Simpson, those that were told to the California police officer, those lies that were told to this court, your admission to sexual abuse running in your family, and then the possible sexual assault that was committed upon you by your brother as a child. And I want to emphasize the lies that she said were told to Detective Simpson, the California police officer, in the court, because that goes back to the 3 factors in Hamilton. Hamilton said that the court has to look at the particular and identifiable characteristics of the defendant that would particularly suggest a restriction is warranted. And in that case, the court said willful disobedience of court orders and I'm paraphrasing, but disrespect for the law in the past can be a reason for a district court to say, hey, I can't give you a more narrowly tailored ban in this case. But there was such an extensive record.
You're given a pretty good reason for some of these special conditions, but it seems like to me it's a lot more detailed than the district court gave. For instance, special condition 9, the defendant shall have no contact with minors unless supervised by competent informed adults. So, for instance, could Mr. RC upon release get a job, say, at McDonald's? Because there will be minors coming up to the counter to order.
He would have to get permission from his probation officer, Your Honor, in order to do that. And there's good reason for that restriction based on the record. Not only did he download child pornography and looked at it, he masturbated to it. And the district court put that into the record in supporting the sentence that she gave to him. So that, in the government's view, would be sufficient to justify.
A lot of these cases that they have evidence that comes in where an expert comes in and granted, the court may have gone a little overboard in some of the requirements we've placed on the district courts, but that's what they are today. They've had expert evidence that comes in and says, well, because of his use of the internet, here are the reasons that this person's characteristics mean he shouldn't have any contact with the internet at all, or his contact should be limited to this, this, and this. And I don't think we have any of that in this case.
That's correct, Your Honor. We don't have that in the record, but our view of the cases is that there's no bright line rule that an expert is required to testify to support these types of conditions in every case. And it wasn't necessary in this case. The key question the court has to look at is whether the district court made a particular individualized assessment of the particular defendant. And we believe that the district judge in this case complied with that obligation by mentioning all the things that I previously emphasized to you in terms of Mr. RC's personal history and characteristics and the nature circumstances of his offense. And more narrowly tailored restrictions were not appropriate in this case because there was just such a strong record of him blowing off the wall. You know, when he was told to turn himself in, he fled to California. When he was approached in California, he was not truthful about his name, his social security number. He denied that there was an arrest warrant against him. And then he got up before the district court and she said at sentencing that she'd never seen anything like it before in her career. And he lied. He provided, untruthful testimony about the encounter. Does that tie
into the special condition that says that he cannot possess any pornographic material, regardless of whether it relates to adults or juveniles?
It ties into the
I thought in Ellis that the court went into some detail on that issue.
It ties into the special conditions to the extent that we're making the argument that a more narrowly tailored ban would not be suitable in this case. Ellis can be distinguished on its facts because the court emphasized in Ellis that that defendant was not before the court for sexual abuse of a child or for a child pornography offense. He was actually there on a supervised release violation based on his failure to comply with GPS monitoring and his previous dishonesty with the probation officer. And there was no evidence in that case or the Roblewski case that computers or the internet played any role in his offenses. I'd also note that in the Roblewski case, the court emphasized that the district court gave an inadequate explanation and just said, these are the standard conditions. These are reasonable and appropriate under the circumstances. And the district court did not do that in this case. Even perhaps without the benefit of some of these cases, she laid out the reasons why she was imposing these special conditions. The district court has broad discretion to fashion the special conditions, and we believe that the district court did not abuse its discretion here in this case. If there aren't any other further questions about supervised release, just to touch briefly on restitution, since I have about 2 minutes left, the district court also acted well within its discretion in awarding restitution to Violet. The district court followed the requirements of Paroline in 2259 by first looking at the general losses that were established by the two experts who evaluated the minor victim, Violet, and determined what her future medical and counseling cost would be based on their assessment of her and based on their experience and training in the field. The district court looked at that and then went through some of the Paroline factors to determine what the appropriate amount would be for Mr. Arce in terms of what he contributed to in establishing Violet's losses. So the district court looked at the number of past defendants who had been subject to restitution orders for Violet. The district court considered the fact that Mr. Arce wasn't involved in the production or distribution of the images of Violet. And perhaps most importantly, the district court specifically looked at the nature of these images. They were horrific, sadistic, masochistic. She was 48 years old at the time, and the district court considered that in determining that $5,000 was an appropriate award of restitution in this case. The defense complains that the district court, didn't properly consider two other factors, but this court's precedent in Dillard and Paroline make clear that the factors are just that. They're factors, they're rough guideposts. There's not a bright line rule that the district court must consider or has to consider all of these things. And the district court certainly acted within its discretion in this case.
What happens it's not going to apply in this case, but in the next case or a case soon to come, where here the established amount of future compensation is not that much greater now than the amount that has been awarded over time. So in the coming case where you reach that point, does that defendant not have a restitution obligation?
We don't believe so, Your Honor. The 2259 is pretty broad in terms of the restitutionary purpose. And we made the point in our sentencing position paper that unfortunately, in the vast majority of these cases, these victims are never made whole because the defendants are never able to meet their full restitution obligation. So just because Violet might have a restitution award of $700,000 doesn't mean that all these defendants, including Mr. Arce, are ultimately going to make good on it. So that should factor into the court's analysis. And I see that I'm out of time. So for the reasons I've said today and in our brief, we would ask that you affirm the district court's convictions and sentence. Thank you
very much. Mr. Theurer, you've got some time on rebuttal.
Thank you, Your Honor. Judge Floyd, to address your issue on the conditions of supervised release, again, Hamilton makes clear that when you're dealing with a non-contact offense, which is what Mr. Arce has here, the massive deprivation of liberty reflected by a lifetime internet ban is simply not supported. And Wroblewski and Ellis, they're not really distinguishable because they came to you on a supervised release violation, but the underlying convictions that led to supervised release show that the conduct was much more, was contact as opposed to non-contact. So here, there was no particularized analysis by the district court as to why a lifetime ban on internet use, a lifetime ban on contact with minors, a lifetime ban on pictures of nudity was constitutional or appropriate here. I do want to touch very quickly on...
Since the district court didn't have the benefit of Ellis and Hamilton and some other cases, would we in this case simply send it back to the district court to have it take account of those cases and get another shot at it?
I believe this court's decisions are clear that remand is the appropriate remedy if it finds that those conditions are not properly supported. I would like to point out something that my colleague brought up. 701 lay opinion expert testimony cannot rely on hearsay. So Mr. Montoya can't testify as a lay opinion without being qualified as an expert by relying on Griffey or anything else. And that's the same issue that we had with Detective Simpson, who would basically, through ostensibly as a lay opinion testimony, did a forensic video analysis to compare a thumbnail, 1 inch by 1 inch image, to a video, again, over objection at trial. And these evidentiary issues, when you're looking at the harmless error issue under Rule 52, they add up. We had this improper lay opinion testimony. We have no evidence that any images on the Alcatel were viewed because none of them had access dates. So it's an for knowledge, it's entirely predicated on circumstantial evidence derived from the lay opinion of Simpson, derived from Montoya, the improper res gestae evidence in which you've got downloads a year prior from 2 IP addresses where the government admitted they had no idea who was on the other end of that IP address. They never recovered any images from those downloads on any of the devices Mr. Arce had. And they have no idea even what device was on the other side of that IP address at the time of those downloads. That is not res gestae. That's like the gun and more, where the court said you can't show the guy had a different gun to prove he had a second gun in this indictment. The counts that were charged were for specific files, and those files were not present in any of those downloads from 2 years prior that the court let in as res gestae. All these things together, the inadmissible expert report, the improper lay opinion, the improper res gestae, that is what the government concedes it relies upon to show knowledge. When a defense against the insufficiency of evidence argument in its brief on pages 42 and 43, it's relying upon this very evidence. Well, I believe that establishes the harmless error that I need to show. It is not highly probable the error did not affect the judgment when you take these various things together. The circumstantial case for knowledge, when you have no access dates, and this is not, again, this court has cases where they have found circumstantial evidence like this to be sufficient when there was evidence of multiple devices with child pornography, a savvy collector, someone with 10 years of experience.
Or a confession?
Well, I'm back to my attack on the confession, Your Honor, right? I'm presenting a package deal. And my package deal is that you have a coerced confession, you have improper evidentiary rulings that...
They sort of all go together. I mean, I accept the chain's got to start from the confession, it's got to go to the search, and then that sort of bleeds into the evidentiary issues. But you sort of got to run the table. You don't have to admit that. I'll withdraw the question.
I see that my time is over. Your Honor, I would simply ask the court to reverse the convictions and sentence of Mr. Arce. Thank you very much.
Thank you very much. I guess council's aware we have a longstanding tradition of coming down to shake hands with counsel, but we're interdicted from doing so still. So hopefully the next time that you return, we'll be able to come down and do that. So I want to thank both counsel for their arguments. Mr. Thierer, I see you're court appointed, and we want to give special thanks to you because the court could not discharge its functions unless folks like you agreed to undertake these cases. Yeah. So thank you all very much. We'll now move on to our last case as soon as the council can change out. Walton versus Harker. Mr. Lewis.
Good afternoon, Your Honor. May it please the court. My name is Tim Lewis.
Mr. Lewis, you can take your mask off.
Thank you so much, sir. I appreciate that. My name is Tim Lewis. I am an attorney at Gibbs and Holmes in Charleston, South Carolina. I'm here today. Good to see a couple of South Carolina guys on the panel. I'm here today on behalf of appellant Kathy Walton. Ms. Walton has been a client of our office for many, many years, and she recently concluded her very long civil service career with the many iterations of the entity that has been located in the area that NIWIC now resides. It was formerly SPAWAR. Before that, it was the Naval Supply Center. And she's basically, as she puts it, has been there as long as dirt. She started there in 1979. I think we have 1981 in our brief, but she actually informed me that it was 1979 that she had been there. So it's been quite some time that she was with SPAWAR. And she's always been an individual who has had to fight for what she got in her entire life. She grew up in Alabama in what she calls a shack. She was the daughter of, she was the 8th child in an African-American family in Alabama as a female. And she rose up through the ranks of the civil service, got a bachelor's degree, ended up getting her master's degree, and had a successful career for the most part as a contract specialist with the Department of the Navy. So what we're here today to do is avoid what we believe is a miscarriage of justice. Basically, when you're presented with when a court is presented with such clear, direct evidence of retaliation, a court must allow a jury to hear the matter to render a verdict. So here, the appellate appeals the determination that the district court made that she was not retaliated against because of her history of EEO complaints when she was denied admission to the CPI, which is the contract process improvement team, and later, and she was reassigned to a demoted position that effectively stonewalled her ability to get promoted within the government.
So that's not being assigned to the CPI team as one of your claims that you put forward of retaliation?
Well, yes, it is, and the way we look at it is that
the reason I asked that question is I don't see where that was ever pled.
It wasn't pled, but the reason it wasn't pled was because at the time she could have had no idea that happened.
Yeah, but I don't think it was ever pled in your complaint.
That's correct. In the amended complaint, it was never. The information regarding the CPI team did not come out until very late in discovery in a deposition.
So how can you recover on a claim you've never pled?
Because it was administratively exhausted. So what has happened and what's before this court?
It was administratively exhausted if you've never put it in your complaint, if you've never pled it. So, what's the basis to recover on a claim that essentially doesn't exist?
Well, it does exist because when the claim was first filed, when her administrative claim was filed, it put the Navy on notice that they should have discovered during a reasonable investigation into the matters that she claimed that this occurred. It was based on the same actor, the same type of retaliation, the same time frame.
I mean, we'll just assume for purposes of present argument that that's correct. We'll assume it.
Yes, sir.
But it never made it into your pleadings.
That's correct. What we're trying to do is get to for us, it's retaliation. And this is the same type of retaliation we pled. And she pled there's 3 paragraphs within her complaint. I believe it's paragraph.
So your thesis is that you can recover for retaliation for acts that you've never pled?
Not necessarily, Your Honor. We believe that it's in the complaint, not directly, but it's in the complaint in such a way that it would have put the defendant on notice that was part of what we were claiming.
So what part of the complaint were they supposed to imply this from?
Well, I could pull out the complaint and tell you again. I believe it's paragraphs 11, 16, and 18. I have that in here, Your Honor. I can get it for you. And I apologize for not having that prepared, but what our main point is not that because you understand that what summary judgment was granted on was her failure to administratively exhaust this particular portion of her complaint. And what the magistrate judge and subsequently the district court judge found was that when basically their ruling was that when she did not administratively exhaust the claim, that they didn't even have to look into it to determine whether or not it was retaliatory or not.
Well, the only issue the EEOC accepted was whether Ms. Walton was retaliated against when she was reassigned from the administrative branch to the task orders branch of the contract's competency. I'm not aware of there being any mention anywhere in any of the EEO documents, anything about a CPI team.
That is absolutely correct. There is not any mention. But as you know, a plaintiff can for the first time bring a new claim of retaliation or another claim, if you go by the Stewart v. Inaco case, that you can bring that for the first time at the summary judgment stage if the claim was properly administratively exhausted. And that's what we're claiming here, that was enough to get us to a jury on that issue. So my paragraph 11 of our complaint, plaintiff has applied for multiple promotions since 1999, has been consistently denied the opportunity for advancement. The CPI team is an opportunity for advancement. Exactly. And we didn't write the word CPI team in there, but we said opportunities for advancement. That's the same exact thing for us.
So there was proof proffered to the district court about that?
You're on there. Okay.
Because we're not at a motion to dismiss.
Right.
This is summary judgment, correct?
Right. So the proof is
you got to have some evidence.
The evidence is clear, is direct and clear as it could possibly be. Nita Bergsteiner, who is a high-level manager at Spaywar, testified in her deposition that plaintiff's direct supervisor, Donna Johnson, said, I am not going to put her on this team because of she might file an EEO complaint against me, or she might file an EEO lawsuit. I could read that directly to you, the quote from her deposition, if you'd like, Your Honor. But what that's only part of the evidence. In fact, Audrey Orvin, who was plaintiff's second level supervisor, was the one who was asking about why Ms. Walton was not being allowed to be put on this team. And when Ms. Orvin asked Donna Johnson that question, Donna Johnson, who is an individual that was named in the original EEO complaint as someone retaliating against her, she said, I'm not going to do it because she's going to file another EEO lawsuit. That's as direct evidence as can be as to what
deal with this movement from one section to the other. Correct?
I'm sorry, sir?
Your EEO claim said it was the movement from one section to the other.
Well, that is, yes, that was one of the three claims that were accepted by the agency and part of the investigation. But again, our point is, and the precedent of this court is that if there is something that is reasonably related to the original investigation, then that matter can be brought later without having to plead it or having to bring it up.
Why is this reasonably related?
Okay, good question. So what we have is the same actor, Donna Johnson, doing the similar type of retaliation. And this.
So what did Donna Johnson have to do with this reassignment from one section to the other?
Well, Donna Johnson was part of another part of that complaint. That again, there were three facets of the EEO complaint. Number one, Donna Johnson retaliated.
You've only got one that survives.
Well, that's not true for the investigative phase, Your Honor. So the investigation took place on all three. Those were the three accepted claims. We, at summary judgment, after reviewing all the evidence, determined that we did not have enough evidence to go forward on two of the three claims. So we dropped two of the three claims at summary judgment. That doesn't mean the investigation didn't happen and that the defendant wasn't on notice of the potential retaliation that Ms. Johnson actually made. So our point is that is such direct evidence of Ms. Johnson coming out outright and saying, I'm not doing this because of her EEO stuff. It's a direct statement about our clients' promotional opportunities within the government. And when you have something that's that direct, we don't even get to McDonnell Douglas stuff at all here. That creates a genuine issue of fact.
what is there in the complaint or in any of the evidence, either at the EEO or that you proffered to the district court, that Donna Johnson had anything to do with any promotions?
Okay. First of all, she was her direct supervisor. Number one, she was responsible for Miss Walton's performance reviews. She was named in the complaint as the individual who retaliated against Miss Walton by giving her a bad performance review in 2012. And again, that was one of the three claims that was accepted by the agency EEO and investigated. Now, this isn't the EEO office outside of the agency. This is the SPAWAR EEO office that we're talking about. So when they investigated her claim that Donna Johnson retaliated against her, that performance review came out in October of 2012. This alleged conversation that, again, for the purposes of this talk today, it happened because it's, we got to presume everything in our favor for the purposes of summary judgment. But that conversation between Nina Bergsteiner, Donna Johnson, and Audrey Orvin occurred in the late summer, early fall of 2012. That's directly within the time frame of that investigated EEO complaint, and directly the same exact supervisor doing very similar, at least similar enough to put the defendant on notice.
Yeah, but what does that have to do with promotions? There's nothing pled in the complaint that I've seen, and I'm not aware of any evidence in either the administrative record or the district court records that tells you these are the promotions I saw it, these were the qualifications, whether Donna Johnson or anybody else had anything to do with any of those, who was selected, who did the selecting, what the qualifications were, why mine were superior. There's none of that anywhere.
Right. I don't think we need to have that because, number one, the defendant admitted in their answer that Ms. Walton applied for promotions after the time that she filed the complaint.
Yeah, but that doesn't prove, what does that prove though? I mean, we're not at a motion to dismiss. It's a motion for summary judgment. You have to have some evidence.
Well, Your Honor, again, we know that she wasn't promoted to the CPI team. We know that 100%. And that's for the purposes of this, that's all that we need. We know that she had Donna Johnson had the retaliatory animus to do this. She said it out loud. She didn't hide it. And we have the rare occasion where somebody within that room came out and said what exactly happened. So I understand what you're saying about having comparators and having all these promotional things, but to us, when they admitted that yes, she has applied for promotions, it is undisputed that she has not received a promotion since 1999, and that is absolutely undisputed within the record. So because she applied for promotions and they admitted she did, and she hasn't received one, two things that are undisputed, we know that those things didn't happen. So are we claiming separate, distinct, discrete acts of not being promoted in this case? Absolutely not. That's not what we're going for here. What we're trying to show you is that there is such direct evidence on this specific type of promotion that is clear from an upper level individual within SPAWAR who testified about it credibly under oath at the end of the discovery period. It should have given us at least enough to get through to a jury to determine whether or not that there was enough retaliatory animus there to sustain any of our causes of action. Now, again, we're down to the retaliation. That's all we got. We have retaliation based on the CPI team and retaliation based on the move to a different area of the contracting section of SPAWAR. So those things in our minds, retaliation, as you know, when a plaintiff has a retaliation claim, they get a lot more leeway than they would normally with a regular discrimination claim. These things aren't supposed to be tripwires for plaintiffs. We're talking about a woman who filed this complaint by herself, and she filed it within the agency, didn't know exactly what the statutory stuff was, and could have had no clue at the time that she filed this that Donna Johnson was taking these retaliatory actions against her. So what we filed.
Your position that Ms. Johnson made both decisions, that she reorganized the company and she made the decision on the CPI team as to who was going to be on it. Was she the ultimate decision maker for both?
For the CPI team, 100%, Your Honor. No doubt about that. For the other portion, she was just part of a group of people who was making that decision. The main
Is there evidence that she was a decision maker? I didn't understand her to be a decision maker there. That seemed like to be a broader issue than she was at.
I see I am out of time here. Would you like me to answer that question?
Judge Agee's permission.
Go ahead.
Thank you. So you're correct. On the CPI team, she was the direct decision maker. On the other side of it, on the moving to a different part of the contract administration, she was not what I would call a decision maker under the law.
You suggested that Johnson made those decisions. I was trying to make sure those decisions were made by different people. They may still be reasonably related, or they may not be, but it's not because she made both decisions.
Correct. In this organization, it's a line of individuals. You have first tier, second tier, third tier. She was the first tier, and the second and third tier, and I think maybe the fourth tier were involved in making the decision on the other part. Thank you so much.
All right, you've got some time left on rebuttal. Mr. Jordan?
Thank you, Your Honor. May it please the court. My name is Will Jordan, and I represent the United States of America. Kathy Walton's claim that was before the district court was that her 2013 realignment was retaliatory in violation of Title VII and the Age Discrimination in Employment Act. The district court correctly held that Ms. Walton had failed to establish that claim as a matter of law because Ms. Walton failed to establish a causal link between her 2005 and 2007 EEO activity and the 2013 realignment. Additionally, the government set forth a legitimate non-discriminatory reason for the 2013 realignment. Ms. Walton failed to produce any evidence to rebut the asserted non-discriminatory reason and thus did not meet her burden of showing pretext. For those reasons, this court should affirm the district court's grant of summary judgment in the government's favor. Your Honors, any claims based upon the CPI team and the failure to promote were not administratively exhausted as the district court held. Interestingly, those claims were addressed by the district court first in the R&R that was recommending the dismissal of Ms. Walton's claims, and prior to that had not been addressed. The charges before the administrative agency were 3 charges, one relating to a 2012 performance appraisal, one relating to a 2013 realignment, and one relating to lower pay than comparable coworkers. The allegations regarding the CPI team exclusion and the failure to promote were not anywhere within the administrative charge. They were not developed in the course of the investigation by the EEO agency. If you look at the agency's notice of acknowledgement of claims, which is in the joint appendix at 196 to 97, there's no reference to those items. It's not addressed. Those items are not addressed in the EEOC's decision affirming dismissal of Ms. Walton's claims at the administrative level.
But your colleague says he agrees with all that, right? Yeah, they're not there, but they're reasonably related. Tell me why they're not. I mean, we've got all these cases that sort of walk through the various, sort of factors of how this reasonable relation test plays out. Why is this, the CPI piece of the story, not related to, the performance review and the lower pay claims? I think he's saying those more so than the realignment claim, but maybe not.
Sure, Judge Richardson. So if you look at the court's decision in Chaco, it has this statement that the allegation of a discrete act in an administrative charge is insufficient when the plaintiff subsequently alleges a broader pattern of misconduct. And that's what we're dealing with here. The plaintiff had alleged 3 discrete acts that she based her administrative claim on. And then when she gets into the lawsuit, she gets into discovery, she starts making additional broader allegations about a failure to promote absence from the CPI team. The CPI team simply, it's not based on the 2013 realignment. Counsel for Ms. Walton referred to the decision makers. They were different decision makers. Plaintiff pled in her complaint in this case that it was Mr. Paggi that reassigned plaintiff to an undesirable position. That is paragraph 18 of the amended complaint at page 11 of the joint appendix. So we've got different.
Fine, but so I think his argument is, all right, yeah, I sort of concede they're probably different actors with respect to the realignment, but I take his argument to be, but the performance review that she alleged was discriminatory was the same actor.
That's
right?
correct.
That's Miss Johnson. Sorry. And it's like ballpark the same time frame. And you might think a negative performance review and a failure to promote are not like totally different conduct. Those being sort of three of the broad things we've talked about. Why wouldn't I think about it that way? I ignore the realignment for a second, because I think you're right. It's not related to the realignment, but why not the other two?
Sure, Your Honor. So one thing that I would say is that there's no evidence in the record that the CPI team was a denial of a promotion. And so to the extent that she's saying, I got this negative performance review that kept me from getting a promotion, and then I got denied this promotion in the form of a CPI team participation, the record does not indicate that the CPI team inclusion is, quote, a promotion. There's no evidence in the record that it would have increased her salary, increased her grade level or pay level. The other thing that I would point to—
Did it make her more likely to get a promotion? Is there evidence in the record that it would make her more likely to get a promotion? Just evidence in the record, right? I'm not asking if you believe that, right? I'm just asking, is there evidence in the record?
I don't believe there's evidence in the record beyond Miss Walton's own statement that she believed that it was her perception that would have increased her odds of promotion.
Was that rebutted in any way? I mean, it's summary judgment, right? I mean, I understand your position, but if it made her more likely to get a promotion, then that is sort of, if we start talking about a adverse employment action, right?
Well, Your Honor, I don't believe that there's direct evidence in the record that it would have made her more likely to get a promotion. And back to Judge Agee's point, there are no specific allegations about what promotions she applied for. And so this would be a different case if Miss Walton had later applied for a specific position and had been told, you have to be a CPI team leader in order to be considered for this position, and so you're not going to get it. That would be a different case. But here, there's no evidence that a specific job that she applied for was denied to her because of that reason. And moreover, there's no evidence that there's any specific job that she applied for that she should have received. Miss Walton has said, I've been denied promotions. Well, we don't know what she applied for, Your Honor. She could have applied to be the head of the agency for which she could not have been qualified. So without knowing what she applied for, who else applied for it, who was selected, what qualifications they had, it's impossible to assess these failure to promote claims. You know, the other point that I would make on that issue is Nina Bergsteiner the affidavit of Nina Bergsteiner has been used by Ms. Walton in support of her case. Ms. Bergsteiner is an example of why Ms. Walton's claims on the promotion side fail. Ms. Bergsteiner was realigned in 2013. She filed an EEO claim and she was promoted. She is now she was a supervisor over Mrs. Walton. And so to the extent that Ms. Walton claims, as she does in her amended complaint, that this realignment all but erased, that's a quote, all but erased her opportunities for promotion, that is directly contradicted by their primary witness that they rely on in this case, Nina Bergsteiner, who was promoted.
Let me talk with you just a little bit more generally about this. Has Harker or the United States forfeited any challenge to the administrative exhaustion after Fort Bend?
I'm sorry, Your Honor?
Well, to put it this way, was Ms. Walton required to administratively exhaust her legal theories involving failure to promote after Fort Bend v. Davis?
I believe she was, Your Honor. And the court, and I will point the court toward the Stewart case, which was decided by this court in 2019, makes it clear that there is not, as the appellant suggests, some no longer necessary to administratively exhaust retaliation claims. Stewart makes it clear that to the extent that you're bringing retaliation claims, those claims still have to be administratively exhausted before you can bring them to the district court.
Well, could it be waived because the issue wasn't raised until 2 years after the suit was brought?
Well, Your Honor, the issue wasn't raised until Ms. Walton attempted to bring an additional claim before the court. And so, for example, if Ms. Walton had pled in her amended complaint that she was excluded from the CPI team and that that was an adverse action, then it would have been on the agency to plead in response to that complaint that that claim had not been administratively exhausted. What we have here, however, is the alleged conduct excluding her from the CPI team is in 2012 or 2013. The amended complaint is filed, and it's not really until the magistrate judge issues her report and recommendation saying you did not exhaust your claims related to the CPI team and the failure to promote that even becomes an issue. And Your Honor, the other thing that I would point out here that I think is important is the court did not grant summary judgment necessarily on the failure to exhaust. The claim that was before the court was a 2013 realignment. The summary judgment was granted on the basis that she had not proved the 2013 realignment was retaliatory. In the report and recommendation issued by Magistrate Judge Cherry indicated that to the extent that the plaintiff is relying on the CPI team exclusion and the failure to promote to support her claims, those were not administratively exhausted. That really is the first time that this issue came up for the parties. And so certainly at that point, the government responded to it, but the government can't assert failure to exhaust on claims that it doesn't yet know about. Your Honor, even if there was exhaustion of the claims related to the CPI team and the failure to promote, the agency's position is that those claims were not properly pled before the district court. The complaint contains no reference to the CPI team. The complaint generally refers to failure to promote, but does not address that issue in any detail. And so even if the court were to find that there was exhaustion or that exhaustion was not required, the district court should still be affirmed on the basis that Ms. Walton had not properly pled those claims at the district court level. Respectfully, there is no direct evidence of retaliation in this case, particularly as it relates to the 2013 realignment.
Just say that one more time. I guess I'm going to go back and just make sure that I'm understanding the government's position with respect to Judge Floyd's question and then Judge Agee's question from earlier, with respect to the failure to allege the CPI issue, whatever you want to call that, in the complaint. Do you take position that they can, as maybe Magistrate Judge Cherry sort of suggested they could just raise that at summary judgment without having pled it?
I do not, Your Honor. Okay. And we addressed that in our brief in response to summary judgment, that there's well-established case law that you can't amend your pleadings in response to a motion for summary judgment. And so we have made that clear. I believe the point that the government is making is that that even if those claims were exhausted, they were not adequately pled in the amended complaint. And to the extent that they came up in discovery, there was no effort to amend the complaint in order to address those claims.
So what your response, so your colleague, I take it, says in paragraph 11, she says she was consistently denied the opportunity for advancement. And he says that we should interpret that to mean anything, I guess, like any potential for advancement. And the CPI team might be thought of as a promotion, or maybe not, but whatever. That's his theory is that's in paragraph 11, right? What's your response to that?
Well, Your Honor, I don't believe that when it comes to a lack of a failure to promote, and if you're looking at the standards for a retaliation claim, which is an adverse act, EEO activity, and a causal link between the two, I think the problem with asserting this broad, I was generally denied promotional opportunities, is that it's impossible to meet that standard because you're not able to connect an adverse act and EEO activity when you're saying over the course of a 25-year career at the government agency, I was denied promotional opportunities.
Is that the same? I mean, if the plaintiff just pled in the last 30 years, I've been subject to adverse employment actions, period. I assume you'd make sort of the same argument that you can't then show up at summary judgment and be like, all right, here are the 17 actions that I included.
Exactly, Your Honor. I mean, perhaps they could, I don't know how the government will respond to that complaint itself, but perhaps throughout the course of discovery, the plaintiff could identify what specifically they were dealing with. But here, there's no reference to the CPI team. It doesn't come up until late in the case and really isn't addressed until summary judgment.
Well, if we were to find that Walton was not required to administratively exhaust, would what Johnson alleged, would Johnson's alleged statement be direct evidence of retaliation?
So I think that Johnson's statement, if you get past the failure to exhaust issue, Johnson's statement admittedly is direct evidence of the CPI team exclusion. I don't think there's any way around that. If what Johnson said is accurate, then that is direct evidence that she was excluded from the CPI team because of prior EEO activity. I think the issue there, Your Honor, is that, again, it wasn't pled, and there also is not evidence in the record that this exclusion from the CPI team was an adverse act sufficient to satisfy the standard for retaliation, which I believe the court would still require Ms. Walton to do. I would also indicate or mention, Your Honors, that the statement by Ms. Johnson, the alleged statement about exclusion from the CPI team, is not direct evidence of any other type of retaliation with respect to the realignment or lack of promotional opportunities. The court in Stover made it clear that direct evidence must demonstrate that the forbidden consideration was a determining factor in the challenged conduct. And so it cannot relate to other conduct. It must relate to the challenged conduct. And the court has also, in O'Connor, which is cited on page 18 of our brief, indicated that direct evidence is such that would prove the existence of a fact without any inferences or presumptions. And so with respect to these other allegations about the 2013 realignment, lack of promotional opportunities, it's the government's position that under Stover and O'Connor, that is not direct evidence of retaliation. The court also correctly determined that there was no causal link between the 2007 and 2005 EEO activity and the 2013 realignment that Ms. Walton has complained about. There's no question that there's no temporal proximity, as the court has discussed, between the EEO activity and the complaint of conduct. And if you look at the Johnson case, which is from this court in 2008, it finds that the plaintiff relying on alleged retaliatory events that occurred more than 3.5 years after the first EEO charge did not support a claim for retaliation. And so here we have the plaintiff relying on action in 2012 and 2013 that she claims was a pattern of antagonism, but that is dating back to the 2007 EEO activity, and under Johnson is insufficient to support the causal link. Finally, the court correctly determined that there was a legitimate non-discriminatory reason for the realignment. There was a change in Congress. Congress decided to change the law. The change in that law dictated a shift within the agency from multi-award contracts to single award contracts, which resulted in a need within the agency to have individuals with source selection experience working in the task order section. Ms. Walton herself testified that she had a lot of experience in that area. She was realigned to that area, and that legitimate non-discriminatory reason has not been rebutted by Ms. Walton, and so fails as a matter of law. Your Honors, I'm happy to answer any questions. Otherwise, we will rest on our briefs.
Thank you very much, Mr. Jordan. Mr. Lewis, you've got some rebuttal time.
Your Honor, thank you so much. Briefly, there a couple of things that Mr. Jordan said I wanted to correct. There is evidence in the record that the CPI team would have been at least some form of promotion on our joint appendix, page 274. It's page 58 of Patricia Johnson, not Donna Johnson, two different Johnsons. Patricia Johnson's deposition, and I'll quote here. Well, because had Kathy maybe had the opportunity to be in the CPI events for the core processes that Donna would not allow her to be in or Audrey override. It allowed her, all right, she could have had, an opportunity to put that expertise not only on her resume, but if there were interview questions, she would have been able to respond to them. That's the brief evidence I found in the record, just glancing as he was doing this. And Mr. Jordan, my friend, Mr. Jordan, mentions
That suggestion is that any lateral move would, in your view, necessarily be an adverse employment action. Because I could always say, oh, well, they do something slightly different, right? Instead of screwing on the screw, right, they hammer the nail.
Right.
And had I been interviewed about hammering a nail, I would have then been able to talk about it. So that would suggest that every lateral move is an adverse employment action. And we've said that's not true, right?
You have, and I agree with you on that. And unfortunately with the time I was given to pull that out, that's all I could find. I believe there is other evidence, but I cannot quote it as we stand here today. Right. I would say that at least it's something that shows that there was some sort of advantage to being on the CPI team that may have helped her with promotional opportunities down the line. I do understand your point, though, Your Honor. Nina Bergsteiner, he mentioned that she was promoted. She was promoted because she filed an EEO complaint, and we settled that EEO complaint with her being promoted. That was how she got the promotion. And I know because I was the attorney on that case. So there were three ladies who came to my office on the same exact day: Patricia Johnson, Nina Bergsteiner, and Kathy Walton. All three of them complained that they were being realigned to a undesirable demotion position. Two of them were Caucasian. One of them was African American. Two of them they settled very early in the process. Just some background on that. So the hard part about this case, and I think, and I totally understand where y'all are coming from on this one, but the real hard part about it is we know, and as Mr. Jordan admitted just a minute ago, we know for sure that she was retaliated against, that the CPI team, not putting her on the CPI team was retaliation. We know that 100%. The question is whether or not she has a claim for that in this lawsuit. And that's why it's a difficult decision. The other portion of the complaint, the other portion that we're arguing here today about the realignment and about her moving to that section, we believe at the time that we filed this lawsuit, we believe that was the major portion of this complaint, because as I said, we had two other individuals who had the same exact move happen that we both settled very quickly on that. So when we determined later on that wasn't going to happen, there was a difference of opinion as to whether or not this was actually a adverse action or not. And that's why it became a difficult thing to deal with at summary judgment. However, let me see. Oh, and the Chaco case is just nothing like this case at all. As I'm sure you all have read it, and I know you know it. But the Chaco case was one where it went to trial, and the fella brought out a bunch of stuff about people calling him names that had never been nowhere near the administrative complaint. This is totally more like the Snyder case. I believe Judge Floyd, you were on that panel, and the Snyder case was, it was a similar enough in the administrative charge that it put the defendant on notice that this stuff may have happened and that they should have administratively exhausted it. And Your Honors, if you all have any questions, I'm happy to answer them. But that's, I think, all I got for you.
Thank you very much. We appreciate the argument of both counsel. As you know, our tradition is to come down and shake hands with counsel after argument, but that's not in the cards for us during this term of court. So we hope you'll return in the future, and we'll be able to do that. With that, I'll ask the clerk to adjourn court until tomorrow morning.
Thank you, John.